is the party which does not get justice due to inaction of the court in the following mandate of the law must have a remedy. So we are of the view that in case where the mandate of 39(3)(a) is flouted, the aggrieved party shall be entitled to a right of appeal, notwithstanding the pendency of the application for grant or vacation of a temporary injunction against the order remaining in force. So if 3A is violated, that is in 30 days, they are not heard and it is not decided and reasons are not recorded, then he gets a right to appeal. The 30 days are getting, the order is passed on 6th of May, the 30 days are getting over on 6th of June. Today we are on 22nd of May. And he has appeared, not sought any hearing, not filed his reply. In such appeal, if preferred, the appellate court shall be obliged to entertain the appeal and further to take note of the omission of the subordinate court in complying with the provisions of 3A. The last 4 lines are on the administrative side. Now, what remains is petitioner to. Because the Supreme Court, and following this judgment, Your Ladyship, 2 decisions of our court, which Your Ladyship may kindly have a look. One is a judgment in appeal from order 99 of 2019. In fact, where my learned friend also, sorry, not the second judgment. Appeal from order 48 of 21. Now, what remains is petitioner to. Because the Supreme Court, and Your Ladyship, 2 decisions of our court, which Your Ladyship may kindly have a look. One is a judgment in appeal from order 99 of 2019. In fact, where my learned friend also, sorry, not the second. Now come straight away. Appeal from order 48 of 21. Para 8. Now, what remains is petitioner to. Because the Supreme Court, and our court, which Your Ladyship may kindly have a look. One is a judgment in appeal from order 99 of 2019. In fact, where my learned friend also, sorry, not the second. Now come straight away. Appeal from order 48 of 21. 8 para 8. Now, what remains is petitioner to. Because the Supreme Court, and para 16 quoted portion. Our court, which Your Ladyship may kindly have a look. One is a judgment in.
Yes.
May I read?
Yes.
Though the impugned order cannot be said to be a well-reasoned order, there the question was that even if reasons were not appropriate, at the same time it cannot be said that the court has not applied its mind to the relevant factors. And as noticed earlier, the court has specifically recorded the principles of ad interim injunction, namely prima facie case, availability of balance of convenience in favor of the plaintiff suffering irreparable injury, and also has found that grant of ex parte will not be granted, the delay would defeat justice. As held by the Supreme Court in Venkat Subaya versus Chelappal, that is the judgment which I read before, Your Ladyship. If a court passes an injunction but does not record, such order can deem to be contain such requirements at least by implication, even if they are not stated in so many words. Adverting to the impugned order, it is not possible to state that it is an absolutely non-reasoned order, wherein parrot-like reference is made to statutory provisions, and reading the order as a whole, it is not possible to state that the requirements of proviso to Rule 3 of Order 39 of the first schedule to code are not met with. As discussed earlier, the commercial court has not assigned elaborate reasons for granting ex parte injunction, but from the facts and contentions recorded by it, it is evident that the court has applied its mind to the same, and on that basis has found that the principles of grant of ex parte are duly complied with. Then kindly see para 18. In the opinion of this court, considering the impugned order as a whole, it cannot be said that the commercial court has not recorded brief reasons for grant. In the light of the fact that this court has found that the requirements of Rule 339 are substantially satisfied, it is not necessary to go into the larger question whether interim would be governed by 135 of the trademarks issue. While it would be an ideal situation if trial court passes an order duly discussing the factors which wait for it in Morgan Stanley. However, if the order reflects due application of mind to such factors, merely because such order does not discuss such factors in detail, it would not stand vitiated on account of elaborate discussion. Then kindly come to para 21. The court in the above decision has held that the appellate court should not flimsily, whimsically, or lightly interfere in the exercise of discretion by a subordinate court, unless such exercise is palpably perverse. At the cost of retaliation, it may be stated that it is not possible to state that the impugned order is palpably perverse, so as to warrant interference at this stage of grant of ex parte when the parties are yet to be heard on the application for injunction. Besides, the impugned order is an ex parte order. Therefore, all that the concerned court would record is a prima facie view based upon the pleadings and submissions advanced on behalf of the plaintiff and record before it. Such an order cannot be expected to contain detailed reasons as an order granting injunction after bi-parte hearing. And this is also important, 22, because same there, here as they appeared and did not file. Another matter of the aspect is that while by the impugned order, the matter was posted immediately on 20th March. On that date, on account of request on made behalf of the appellant, the matter was adjourned to 30th 2019, on which date the appellant once again sought reasonable time to file his reply, whereby the commercial court has posted the matter on 20th June. To be fair to the appellant on both dates, so and so the learned advocate requests the court to vacate. However, from the record, it appears as not ready to proceed with the injunction application on merits. Under the circumstances granted, the question of vacating merely does not arise. Nonetheless, Rule 3A provides so and so, so and so. Having regard to the provisions of 3A, the commercial court ought to have made an endeavor to finally, merely because the trade for time was no reason. However, learned Kara shows willingness to proceed, and therefore it was not inferred. See para 9 what the division bench says after noting this. Therefore, the above decision would apply in the facts of the case, as also pursuant of the impugned order dated with the considered relevant provisions for the factors of the purpose of grant of ex parte under para 3. 10. It is true that the impugned order cannot be said to be well reasoned, but at the same time, it cannot be said that the court has not applied to its mind to the relevant facts. In view of the observations made by the division bench of this court, more particularly 16 to 19, it would not be in the interest of justice to interfere in the impugned order at this stage. With a rider and reminder to the trial court that the ratio laid down in the aforesaid decision be kept in mind in future while passing, it would not have been proper without adequate reason held in view of the above to expeditiously as so and so. And then, Lordship, a two-pronged submission before leadership is that first, the Supreme Court judgment says appeal is not maintainable except where Rule 3 is violated. Secondly, even where the appeal was heard, the reasons, the merits, whether injunction should not have been granted and what view your ladyship would take is not the consideration for interference. As long as the trial court has applied its mind and taken a view, right or wrong, your ladyship should not interfere. Because even otherwise, let me presume for the sake of argument that an appeal lies before your ladyship on this and your ladyships are considering the appeal. The scope of appeal is very well settled by the settled decision of
it's not on medical feeling. Now, let me answer. Let me answer.
So that will be only on principle. So on both these facts, my request is that the 30-day period is anyway getting over on 6th of June. I am ready. Whenever my learned friend says, whenever your ladyship fixes a timetable, we are ready to go there. Let them file their reply and let the matter be heard before the 30 days. Your ladyship will certainly not hear without the benefit of even their reply, their case, with the trial court having not had an opportunity. And in teeth of the Supreme Court judgment that appeals are not maintainable under Order Rule 3, only when 3A is violated, the defendant will get a right to maintain an appeal before your ladyship. The Supreme Court judgment is very clear. And they appeared in the court on 17th. They filed their wakalatnama. They have the time and the effort to file an appeal before a ladyship, bringing on record everything. But they don't want to file a reply below and submit to the jurisdiction where they are supposed to under law. They have neither filed a 39-4. They have not given a pursuit for early hearing. They have not given that please hear or vacate or modify the hearing. Nothing. They simply filed their wakalatnama. That order is available. In fact, the order is also, in fact, ladyship may see on 17th, they have appeared. This is the printout from the site of the Hon'Ble City Civil Court. Kindly have a look at the top. Resume today. Court number so and so, learned advocate are present, has filed VP, recorded learned for the defendant filed an application for inspection of R&P, kept for filing of reply. So we can't bypass the entire procedure, otherwise this will open a floodgate. Every time there is an ex parte order, immediately appeal here. And time and again this court has held that we will not interfere, we will send it back unless it is absolutely no reasons were recorded or nothing. Otherwise, an appeal under 3 is not maintainable as held by the Supreme Court. Even if we apply the Commercial Courts Act, it still has the same rigor, 43(1). So my preliminary objection may be considered that the appeal is not maintainable.
First, the judgment which cited by the that
We are still on
itself I am entitled to file the Supreme Court.
Yes.
Because on that ground, my appeal was heard on merits in the second case, which is cited by my learned friend of this honorable court, that does not say that appeal does not lie. Appeal was filed against ex parte order, that is maintainable. Now kindly consider what this judgment of the Supreme Court says, by what is their application, whether power is flowing from order 39 rule 3 or from rule 1. I may go to the statute, but in this case, I would like to take a divergence. Kindly turn to page number 699 of the internal page 699 of the judgment of the Supreme Court, which my learned friend has cited, para 11. Any grant of the ex parte order would be under order 39 rule 1 only. That's what Supreme Court says. And I am not on order 39 rule 3. That is presuming what I am going to argue. Order 43 rule 1 says that an appeal shall lie from the following orders under the provisions of section 104, namely then are. Order 39 rule 1 says thus, where in any suit it is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, alienated by any party to the suit or wrongfully sold in execution of the decree, or the defendant threatens or intend to remove so and so, see, I may forget, the court may order grant of the temporary injunction to restrain such act or make such other order for the purpose of staying. So one, that if any party under the damage, this suit is filed by them under the trademark, that my trademark is going to be damaged, it is going to be diluted because my trademark is also similar. Now further, I may go to para 13. It cannot be contended that the power to pass interim ex parte order of the injunction does not emanate from the said rule. In fact, the said rule is the repository of the power to grant orders of the temporary injunction with or without notice, interim or temporary, or till further order, or till the disposal of the suit. Hence, any order passed in exercise of the aforesaid power in Rule 1 would be appealable as indicated in Order 43 Rule 1 of the Code. Now, this is important. The choices for the party affected by the order, either to move the appellate court or to approach the same court which passes the ex parte order for any reason. Now, I may read further. What my learned friend, Order 39 Rule 3 is only a procedural part. That if the court think it fit to pass order under Order 39 Rule 1, then they have to follow this process. If this is violated, then that is mandatory procedure is violated, and therefore the order should be set aside. That is the proposition, and set aside in appeal. That is the procedure. Same court can't challenge I can't challenge the legality and validity of the order before the same court. I can't challenge. I have to challenge in appeal only. That's what the Supreme Court says. Now, not only, before I will read further, in this case, what has happened? Kindly read para 17, para 20, 21, and 22. I must just apprise your addition. The party approached the lower court under Order 39 Rule 3A under 39 Rule 4 to vacate the ex parte order. That was not heard for more than 1 month. Court said that if he has approached under Order 39.3A or to under Order 39 Rule 4, in that case, appeal would not be maintainable because he has already opted one choice. One choice, which one choice? Choice referred in para 30. And again, the last 2 lines from para 30. The choice is for the party affected by the order either to move the appellate court or to approach the same. So if I adopt one choice, then I can't go in appeal. That is the right in subsequent matter. And that rule is also we want to go by. If the matter is posted after 1 month, kindly see, my learned friend is coming before the court like a holy cow. That I have got ex parte, legality, validity, forget, don't challenge the legality and validity. Let us straight go to the merits. I only want the legality and validity of the order, your addition. Now kindly see their application. What is the application? Page 1. This is only my order to, I would say that this is well settled principle that appeal is maintainable. Well settled. Page 1 of my appeal itself. This is only, I would say, my absolutely misguiding submission. Application under Order 39, Rule 1 and 2. Application would file under that only. Now kindly go to that Mohalla Tech judgment. And my learned friend is presuming too much. That I am only on order 39, rule 3. That is procedure. Now kindly see para 2. By this appeal from order under order 43 rule 1R of the code, hereinafter referred to as so and so, the appellant has taken X party ad interim order, trademark so and so, so and so. The learned chamber judge has said so and so. Appeal is not held to be not maintainable. But here the issue was raised under order 39 rule 3. May I go to order 30? I may complete the reading of this. In the case of the appellant, the interim order was served on so and so, therefore appellant would not appear before so and so. The facts aspect, then para 6. The learned senior advocate, Mr. Trivedi, submitted that the learned chamber judge could not have granted ex parte interim order contrary to the provisions of so and so. It's a provision which needs to be followed. Why you are granting relief under order 39 rule 1? Now further, what has happened? The division bench in the case of para 8, which my learned friend has personally referred, that was also again ex parte order, appeal was held to be maintained. I am also having one order in the list with my judgment where the ex parte order appeal was preferred and appeal is allowed on the ground of violation of order 39 rule 3. May I just place that on the record? Further.
See, that is, it will be violated if the thing is not completed within a month.
No, I'm sorry. That is,
If we go to the same judgment, 2007,
yes, that is
See,
not completed.
what does D say?
Yes, what does
I give
it
a
say?
copy of that judgment. 2017.
Let us.
Lakhani.
This, I think, is fairly.
Yes, he exhaustively cited
Yes.
in it.
It says maintainability against order under 39 rule 1, rule of alternative remedy. Principle is well recognized that High Court ought to direct party to seek
Correct.
other available remedies before invoking constitutional remedy. And if you see,
Constitution under Article 227. And
Yes.
here the challenge was under 227, para 22. Here it was challenge under Article 227. Not in
you
the
are coming
kindly
under
see.
43.1.
Yes, it is referred to the provision, but kindly see, it is also under Article 227. That is discussed. Come to para 1. Let us not go by the head note. Let us go by the judgment.
There are 23 onwards, your ladyship.
There are 22 before that. Now,
22.
20,
Let's see 22.
For ex party.
Yes,
May I read from para 1?
yes. No, para 22.
Para 20.
Okay, that is true.
Now, what remains in the question whether the High Court should have entertained petition in Article 227. That is by the supervisory jurisdiction. When the party had two other alternative remedies. Which two other alternative remedies? Appeal as well as order 39 rule 4. Because that is stated in para 13. Kindly see para 13. Though no hurdle can be put against the exercise of the constitutional power of the High Court, it is well recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of such remedies, one or the other, before he resort to the constitutional remedy. Learned single judge need not have entertained the revision petition at all, and the party affected by the interim ex parte order should have been directed to resort to one of the other remedies. Be that as may, now it is idle to embark on the aspect of the High Court has chosen to entertain the revision petition. This is what he said. Now, what do those two remedies? Kindly come to para 13 again. Because what is already provided, two remedies. This case from para 1, 2, and 3, the revisional jurisdiction was involved, jurisdiction under Article 227 was involved. And still High Court has said that this law is laid down and said that there are two remedies. One, para 13, I may read again, my good. This is what, on the contrary, so High Court, Supreme Court direct that you have two remedies. One under order 43 rule 1R, two under order 39 rule 4. You go and exercise any one of them. So I am invoking order 43 rule 1R, read with section 30. It is well within my power. And here I am not on order 39 rule 3, perhaps I am free. So my lord, out of these two, one I can, this is only my lord two, I would say just to derail my hearing, my flow, nothing more than that. This is well settled before this one. So my lord, this is my respectful submission. Now, in view of this, I would say, my lords have already considered my lord order 39 rule 3, I am going to that, but there is a basic principle. I may again read that. I again say that order 39 rule 3 would be one of the limb of the submission, but that is not the submission, which is the only submission on which I am preferring the appeal. I am on the gross illegality of the order, which I can execute against this honorable court. On jurisdiction, court does not have the jurisdiction to pass the order. I am on that. The suit is required to be dismissed. I am on that. Kindly read. Order 39, rule 3, which my runner tendered, so that I may not have to come to that again. Your ladyship may kindly have what should be the criteria under order 39, rule 3. May I just comment? That is already there. So, unless and until the purpose of filing the suit is going to be infatuated, unless and until that situation is there, no ex parte injunction should be granted. That is the first principle. Basic principle under the Civil Procedure Code. Any civil suit under section 9 of CPC or in order 39 rule 3. Order 39 rule 3 is only a procedure to order 39 rule 1 that you can grant the ex parte injunction. But heaven is going to pull if that situation is there, then only you can pass. Now, this was not found sufficient by the legislators, the lawgivers, and therefore the Commercial Court Act is also amended accordingly. This suit is filed under the Commercial Court. Before going to the Commercial Court Act, I may just give a bit of the facts line. The legislature has prepared the text in a kindly. Now, this is the admitted position from the order, from the pleading, from the plaint, from the interim injunction application. And my lord, I would put it very clearly. What they did over here to derail the hearing, that would be continued even before the lower court. But still I am not on that. I am only on the count of legality and validity of the order, whether it would sustain for a minute. Kindly see, this is the position emerging from the order. I have not produced anything. For this submission, I am not required to file any reply. I am reading from the order, from the plaint itself. I am not going on any of my documents. 4/9/2018, the appellant started his restaurant service in Goa in the name of Tomatoes, Beachside Kitchen and Bar. I am running my restaurant in Goa, not in Ahmedabad. Plaintiff is having only restaurant only in Ahmedabad and Gujarat, limited to. As it emerges from the record, he might have some other place, but certainly not at Goa. Certainly not at Goa. I am doing business since 5 years, 5 good years. Up to the January 2023, I am reading further. 8 to 2021, the appellant applied for registration of the trademark in class 43 of the restaurant service. Kindly consider this is important. Restaurant service. Class 43 is important. 20th April 2022, the respondent plaintiff filed trademark application. So, they filed a trademark application number 5416182 for the first time in class 43 for restaurant service. Trademark registrar raised objection against the above trademark application on 30th July 2022, your ladyship. It's not 23. Before 1 year, about 1 year. Trademark registrar raised the objection about trademark application in class 43, citing appellant's trademark and one another's trademark as conflicting prior applied trademark. Now, kindly consider what they answered to this. Item number 4, your ladyship. All these are referred in the order itself. This is what they have produced on the record and referred in the order. Into order itself, despite the order itself. 6/8/2020. Respondent accordingly, this is their pleading, accordingly replied the above objection examination report inter alia also contending. They also contended that we are prior user in different class. Not in this class, different class. So infringement would per se not make any. Also contending. 6th August, their reply. This reply is very, very interesting, your ladyship. Kindly read that. Respondent accordingly replied the above objection examination report inter alia also contending that respondent applied label as a whole different and hence there is no cause of confusion or deception on the part of the label. In class 40, yes, this is part of the reply. No, your application is part of the claim. Your reference of the application is that it's a government record. This is what they have suppressed. This is what they have suppressed before the court, which is a government record, because reply and everything available online before the trademark registry. They have applied. So fortunate for me, the application given advocate appear before the lower court and appearing here is the same amendment. So let them deny that they have not answered this. And this is part of the government record. So under the evidence act, this is straight away enter into the evidence. And this is their duty to disclose. If one is suppressing the material fact, and in appeal they may say that I have not put up my own document and therefore you can't argue. That is unheard of. Now January, March 2023, kindly read my lord this contentions from their plaint itself. There are page number 50. The lordships may kindly see. Page number 15. Para 23, the cause of action of filing of the suit. Your ladyship may kindly see they are already confronted with my mark in July 2022. In August, they replied that my label is also different. Therefore, there is no chance of confusion. And that registration is still pending, not granted. And now kindly see para 23, page 15. Cause of action. It is further submitted. The cause of action filing of the suit arose when the plaintiff come across the reviews of the commitment made by customers and the patrons with regard to the defendant restaurant under the trademark tomatoes being affiliated with the plaintiff restaurant in the month of January, March 2023. So since January they are aware, on 27th of April they are affirming the suit. I would put a question to myself, would it not sufficient to violate order 39 rule 3? If he is waiting to file suit for 3 months, what would have waited to wait for 15 days to give me a notice? And kindly consider, now the order, I am readily agreeable to go with the expedite hearing of the interim injunction application. But today the order is not operative against me. It is made operative from 25th, day after tomorrow it will become in operation for my ongoing restaurant. Let that be stayed. I am not going to open new branch in Ahmedabad. And let the hearing be completed within 10 days thereafter on the 6th or whenever the 1 month is coming. Kindly see the order. Operative pattern. Now I may go to the order. Is this not sufficient for your ladyship to wait for 15 days? If the party himself is coming before the court after a delay of 8 months, after receiving the complaint of the confusion, waiting for 4 months, and still the court passes the ex parte order. And that too, this order 39 rule 3 still it can be given a go by. Let us take it that it is given a go by. But this would be, suit itself is not maintainable. Now let me satisfy that. Kindly consider the order first so that I can go on the judgment. Page 22, the impugn orders. And for this order passed under order 39 rule 1 and 2, that is also under answered in the order itself. The plaintiff company so and so instituted the suit seeking relief of the permanent injunction restraining defendant using plaintiff registered trademark tomatoes. It's a suit for the infringement alone on any mark deceptively similar date to amounting to infringement and for rendition of the account with the ancillary relief. Further, the plaintiff has paid for the damage of so and so. The suit is accompanied with the urgent application exhibit 7 under order 39 rule 1 and 2, playing for ex parte and injunction. The court has passed order under order 39 rule 1 and 2. In so far as the exemption from compliance of section 12 of the Commercial Code 2015 is concerned, since the plaintiff has prayed for an urgent relief under order 39 rule 1 and 2 of the CPCR, mandatory institution of the premeditation would be counterintuitive and would cause prejudice to the plaintiff. Therefore, exemption is granted from compliance of the aforesaid clause. Now, this is not permissible that I am going. This suit itself, this suit is without jurisdiction. Learned counsel submitted the right of the plaintiff are urgently required to be protected at this stage as the plaintiff is a registered proprietor. Since 1994, Though the predecessor title where the defendant has recently started to use the identical trademark tomato, Learned Counsel has invited the trademark register. Learned Counsel has invited attention of this honorable court to registration certificate issued by the trademark registry in the name of the plaintiff at page 35. Your Ladyship, I would humbly request kindly consider this page number. I am going to. Suit will not be maintained. Of the list of the documents appended with the plaintiff, submitting that the plaintiff is the registered proprietor of the trademark tomatoes, which is further submitted that the impugned trademark of the defendant, beachside kitchen and bar, is identical to the well-known trademark of the plaintiff, as also the defendant is carrying the business in the similar trade of establishment in Goa, which likely to cause confusion in the mind of the public, dilute the exclusive right of the plaintiff. Reliance is placed on the several invoices showing approximately turn on the plaintiff of the 50 crore. Goodwill earned over the year, replying to the various pamphlets, also the news article, Instagram page of the plaintiff commented page 36 to 90 and 108 of the document respectively. Learned Counsel, now this is interesting. This judgment itself debarred the court from passing the order that I will show. Learned Counsel has submitted his argument by relying upon the case of JMD Heritage, now Pela 4. Learned Counsel for the plaintiff perused the material on record along with the case law. It is a settled proposition on the registration of the, this line is important. Registration of the trademark is a sine qua non for seeking an action against infringement of the trademark. This is in any case settled thing. In the present suit, the plaintiff trademark tomato was registered in 96. Registration certificate dated 28/11/2005. It is recorded that the plaintiff is use of the said trademark is 1194. Valid till so and so. When the other hand, it appears that from the copy of the application filed by the defendant on 8 February for registration of the trademark and bar, it is using the said trademark since 4/9/2018. This is before the court. A close analysis of the plaintiff registered trademark tomato with the defendant's tomato which side so and so so and so. Further, the document annexed at page 132 to 153. List of the document also shows the general public is getting confused. These all documents are of January, March according to them. So for 5 years there is no confusion. From 4/9/2000 to 18, no confusion up to January 2023. Out of lakhs of customer, only 4% are got confused. So it is 0.003%. After visiting defendant's restaurant, which is operative under the similar identical trademark tomato, besides this, the plaintiff company has also used expenditure reputation, registered as a prior user as a mark, lettering point of time, and public is getting confused. So they are prior user, I am lettering point of time, public is getting confused. That's all. I am since there since 2018. Where this satisfied the need that heaven is going to fill? Where is that? Now let us go by to everything. May I humbly request my lord to Commercial Court Act section 12. This suit is filed under the Commercial Court. Your ladyship may kindly keep the paragraph 2 of the order in juxtaposition to section 12A and the judgment which I cite. Because this proposition was held by the Mumbai High Court by the learned single judge, that is overruled. So this order is based on the overruled principle. That the moment there is interim relief, the 12A can be given a go. Kindly consider section 12A of the Commercial Court. This is inserted since 3rd of May 2018. Kindly consider. The Commercial Court Act came into force since 2015. Thereafter, the same is amended in 2018 and section 12A is specifically amended, interpreted by the Supreme Court as mandated. And suit should be dismissed no matter by the court. That is what the Supreme Court is saying. A suit, am I with you? A suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules made by the central government. May I just humbly request, my lord, there are two relevant parts of this section. Number one, that section 12A is mandatory and that is now interpreted by the Supreme Court in 2020. The relevant would be a suit which does not contemplate any urgent interim relief under 3 steps. So, any suit which is contemplating urgent, contemplate is an important word that is also interpreted by the courts. That contemplate means thoughtful consideration. If the plaintiff has waited for a long time, then per se it is not contemplating any urgent thing. He has waited for 1 month, that is sufficient to dismiss the suit. Suit is dismissed suo motu by the High Court, by the Supreme. I will show that. 1 month delay is sufficient. If the notice is not given, then also it has to be dismissed. Now, contemplate any urgent interim relief, not important. Under this act, that is important. Urgent interim relief would be there, but under this act, what should be under this act? That should be, we can take the color or interpretation of this under this act from the subsequent word. That shall not be instituted unless the plaintiff exhausts remedy for pre-institution mediation. So pre-institution mediation, if that provision is exhausted and keeping that in mind, the contemplation of urgent interim relief under this act should be interpreted. That is the respectful submission that is interpreted by the court. I am going to that. So merely because putting an interim relief would not suffice. Now on this term, now here interestingly, no application is filed separately. 3 respectful submissions. Let us go to the plaintiff. Whether it contemplates interim relief under this act, that I am filing a suit under the commercial court, but premediation would come in my way for certain reasons. Is there any pleading? I have gone through the entire plaint. Let us go to the plaint again. I have also provided the paper. I may read from there. No pleading at all. And the court has just presumed that there is interim relief. So court can't read anything beyond the pleading. Let's well settle. Now page 1. With the paper, see how after 5 years, one is sitting in Goa running a restaurant and bar. He is injuncted after 5-6 years from Gujarat, not waiting for 15 days. And order is coming in force from 25th, after day after tomorrow. Let that part be extended and let us go for the interim, for the by-part hearing before the court below. Within 10 days, I will finish that. The reply is ready. Right now, I must submit the reply.
Can we talk a little?
I'm sorry, it's my natural voice.
I mean, we should be more. Yeah.
May I just address on a couple of issues for
No,
5 minutes?
see, I think, all these have to be agitated before the trial court.
That's right.
Correct?
That's right.
All these points that are being, they are
Absolutely.
not to be this thing. As far as this order is concerned, it is coming into force from 25th.
There are 2 aspects to the order.
One is the,
One is no new outlets.
yes,
which is immediately already-
that he can maybe pass a pushes to that.
I'm answering the court. That I agree.
Maybe he can pass a pushes to that effect because,
Yes.
that we don't intend to open any other branches anywhere. And this portion of the order, which says that 25th,
That's right.
which the injunction granted shall come into effect with, from 25th of May,
That's right.
could be extended for another month
That's right.
till the whole issue is decided by the court under Order
I
39.
will certainly respond to that.
Just to supplement to the
Wait,
circulation. My reply is ready.
I don't know what's your name, but please, let him make a submission. Yes.
Thank you. I will certainly, I may not have much of a problem to that. I'll seek instructions in the meanwhile. If the leadership can only give me 2 minutes to clear the air on certain in 2 minutes.
See,
Otherwise-
all this is not going to go this thing because I don't want to get into all the,
No, I
you know-
with my respectful submission, Hon'Ble versus Entox onwards, principle is that this cannot be gone into once it has been gone. On 12A, the statutory bar that my learned friend is totally misguided.
no,
And the
that
time-
again is not to be decided,
Papa, it is
not to be considered at all here.
Not at all.
Because
Yeah,
if you see if you read the thing, it depends on the discretion of the court. If the court thinks,
No. There, because here the situation is that 12A is mandatory.
yes,
If unless the suit is based for urgent relief.
yes,
Now a trademark suit, like in the circumstances, there's a direct decision of a division bench of the Delhi High Court taking a view that how this suit will not be not for urgent relief. The argument that it should be under this act it is also under this act because the commercial dispute clearly includes disputes relating to intellectual property. That is item 15 of 17 of 2. Section 2, subclause 17 says intellectual property rights related to trademarks, patents, etc. are commercial disputes, and therefore it is a suit even under this
I think
act.
that is
The
clear.
statutory right protection, no, he submitted this urgent relief under this act. So urgent relief under the Commercial Code Act covers
It is,
commercial.
it cover, it, that
So
is very
12 day
clear.
once, and the judgment of the Delhi High Court is to that effect that the plaintiff's intention, the plaintiff's assertion that this is for urgent relief is to be seen as far as section 12A is concerned, not the defendant's argument that this should not be there. That Delhi High Court judgment is
All
also there.
these have to be educated.
I bow
before
down, and
being
therefore
under
the appeal is
trial.
not maintainable, but interference by your ladyship to the effect that this extension may be granted till 25th is
No, in
perhaps
view, because
Huh.
if you see, the matter is posted
on 7th.
on 7th
But
July.
on 17th when they appeared, they have not filed a reply or even given an application that please hear the matter. The court would have certainly heard the matter if they would have applied. They would have asked it. The
Yes.
court, because of the vacation, the court may, and your ladyship's vast experience also knows that while the 30-day period is a salutary provision, I doubt
No, the
whether any
commercial
matters
courts- the commercial courts
get
have to-
30 days get done. But no, I'm not getting into that. Let me presume that an early hearing is required. They could have applied. They have not applied on 17th. They filed their wakalatnama. They seek inspection and seek time to file the reply. And they approach your ladyship on 19th. So what I am saying is otherwise. 10 days, your ladyships are right. Let in 10 days the matter may be over, right?
Yes.
And the injunction we will not enforce till the hearing is completed. Because staying the injunction sends a very wrong message. Both on the ground, can I, but you can join after I sit down. I have not yet completed my.
Just a minute. Because arguing my matter now, my lord.
I have to
You
reply to
so many incorrect statements. Let me just clear that cloud.
my lady.
First, clear.
There's no cloud. Listen, you have, I've heard you enough. Let me listen. Let him complete. Then I'll listen to you.
Please.
My suggestion is that today there is an injunction which according to him comes into effect from 25th as the order.
Yes.
Suppose, let me presume that if the injunction is operating from 25th and the hearing is taking place, and then it cannot be, I agree with my learned friend that he cannot be asked to be saying that he is in violation or breach of the injunction. So my statement and the instructions may be recorded or a process may be, I may be giving
Yes.
process.
It would be
That we
better.
will not enforce or execute the injunction or take a stand that they have violated the injunction till the hearing is completed, and the hearing be completed within 10 days or whatever time that your ladyship stipulates, and it can be completed in a time-bound manner. The usage of the words by your ladyship that the injunction, that part is stayed, what my learned friend is saying, will give a very wrong message, and I would have some objection, then I would like to be heard on merits. But otherwise, I'm not averse to my lady's suggestion. I in fact bow down to that. That is the only practical way of solving, that we
Yes.
go below and the injunction really does not effectively operate against him till the matter is heard within 10 days. But my only difference is on the wordings, that I will give an undertaking that I will not execute or enforce this injunction till the matter is heard within the stipulated time-bound program which your ladyship may fix. And that is the courses that I am ready to pass on. Beyond that, I am not
So
arguing.
you
on
pass a
section.
process to that effect,
To
and
that
you will
effect,
pass a process to that effect,
I-
that you are not intending to open any other outlets.
Yeah, the rest of the order can continue except this part which I will give a courses and undertaking which your lordships may record
Now
statement of Mr. Trivedi along.
let me rephrase that. While underfriend is actually given his view. And more or less we are on the same page. It's all about the wording.
Yes.
So let us put the wording.
You do one thing, you
I
put
will
your
instruct
courses,
to
you
submit
put
this
your
one.
courses, then I will accordingly
No
declare.
problem, sir.
Okay.
Courses perhaps clear statement.
Statements are enough. The courses may not be
I
really
will request
required.
this, the word should be like this. I would put, this is my respectful submission.
Okay.
The Hon'Ble Court has said, kindly go to the order, because we may go by the order. I think that would make the picture clear. Roman 4,
Yes.
insofar as the existing services being provided by dependent, so and so, shall come into effect from 25th July 2030. So this time is given. Now, your ladyship may say that this is the time is given. This Honorable Court may extend that this order will come in the effect This order will
No, no.
come in the
What we will do is,
What I will say is that I will not enforce Roman 4. I will not execute, not enforce,
This is not
or complain of violation.
Order is already passed by the. So contempt is between court and the contempt. I will always be in the contempt. Why I should be in the contempt? I should not be left to the mercy of the other side.
Pay Lordship, let me make it easy. Let me, to that extent, I agree that it's big complication.
Now allow me to just.
But I am saying something in your favor, the court
shall
may,
we say
the
that
court
the
may
time,
extend the time by 10
the
days.
time, the
No,
time,
10 days till the by
No, but
this count is
first-
all time bound.
First, your Lordship's ladyship may fix the schedule.
Yes,
Within
yes.
10 days.
let us, yes,
Like two statement may be
today is
recorded.
the
One,
23rd,
23rd.
I am
when will
giving
you
the
file
reply.
the reply?
Right now I am serving. It is
You will
ready.
have to give it to
No, no, here only advocate is here.
And I will file my rejoinder within 3 days.
Let it be recorded that I have served the reply. Let it be recorded. I am serving the reply. It is ready.
First you serve and then we'll.
No, no, it is ready.
This court is not working as the administrative staff of the
Yes.
civil court. It is a very sad submission on your behalf.
Rather said on your part, but when
You
you
will
have
have to-
personal thing, you will
will have
settle
to-
outside the court.
Wait,
What is personal
Can't be
imputation?
told to your ladyship
Why
as your
is
ladyship will
personal
record
imputation?
reply or-
Serving that may be recorded. That's what I am saying. Is would it amount to administrative function? I can understand your anxiety.
This will have to be placed before the court, no, in the record of the court. You
Reply will have to go there.
Yes.
No difficulty. But if they
No,
want any
you
service,
can serve as copy to him, but you'll have to
They-
present
they-
it before the court.
Your ladyship may say that the.
No problem.
Let us say
No,
we
The
no,
will-
defendants will file their reply by tomorrow
Within-
before the civil court.
Yes,
We will 3
Let
days
us say within
thereafter
2
file our
days.
rejoinder.
and within
3
3
days
days
our
thereafter.
rejoinder and thereafter within a week the matter can be heard.
Yes,
So your ladyship may fix a date that we are on today on 23rd. Let it be heard by
May I-
the
may I
fifth-
just-
the
may I
3rd
say
of
one
June.
more day?
3rd of June.
May I say one more day? To the best of, to
Third
the
of-
benefit of my, one more thing what I am
I am saying not a problem. 3rd.
Your ladyship may record my statement that today I will find the reply before the roll cut and I will have some.
little,
So the time can be set. Let it be.
I'm
Very well. Two more.
Let
No, I have no problem. I'm saying I have no problem.
There are within 2 or 3 days, whatever time they want, they will find the rejoinder, and thereafter, court may endeavor to finish it off within any time before third. That's a fair suggestion. And
On or
if that
before
date, this time may be extended till this bi-party hearing is over, by chance. If it is not over by third, I should not rush to the court again. and say,
They should apply there. We will have to apply
So,
there.
when the question of applying, it is ordered by this honorable.
Not till the
Same court can't do.
till that your ladyship may extend it till 3rd. That is my submission.
Till by-party hearing is over, and if I have breached that.
By party hearing, your ladyship may direct to be over by 3rd and extend it till
This is
3rd.
my lord something
Of course, your
putting
ladyship
the
has the
pressure
power.
on the court.
Of course,
For
there
nothing.
there is a time bound schedule. Every court does it. Every matter it is done.
And I have not entered into the merit for this.
there is vacation in the civil court also.
It's available. Commercial court and so.
Commercial court.
This way.
Reports are available.
One
I'm told they are available.
1 second, no, it's
Because
not.
I think now the
Don't they have
transport.
Just let me, I have something to appraise on the commercial court, I have something to appraise. Now, you please wait for a minute. Please, just a minute.
This is Ahmedabad.
It is in the, what has happened, both the commercial judges have been recently transferred.
So,
So 2 judges have recently resumed the charge. They may be perhaps under the joining period. So I would request that you let the learned principal judge be directed to place it before either the commercial court or person in charge of the commercial court, so that this matter
no,
can be
only the
recorded.
jury
taken a
will
charge.
have the,
There are 2 judges.
Taken a charge,
Judges have
joining
taken a
period,
no,
perhaps,
no.
I don't mind.
That
Not
one
taken.
I don't mind, but if the court is on leave,
But
it
in
is
case
there.
of difficulty,
I
you
have
can
not.
approach your
No,
ladyship.
why we should that much again and again?
But if there is, no, but if there
Very
is, otherwise.
I would-
we'll give them, in case they are on joining. something.
Ladyship may give 2 or 5 days more. There is no
So, the
problem.
learned advocate for the petitioner will file the
I give
claim
I give my.
before the consent court within 2 days. And thereafter, the learned advocate for the respondent will file the rejoinder within 3 days thereafter.
You want 3 days or 1 day more?
My not subject to all my legal contention.
We will file our response by 29th,
So,
Monday, 29th.
Would it not
by
be
29.
putting me to the. Let it be 1 or 2 days.
Yeah, your time is getting extended.
You're not going to
I
be,
want extension. I'm ready to give tomorrow. Let it be after 3 days.
We'll file it on 27th.
27.
We will file on 27th.
so within 3 days, I say.
3 days.
Correct.
Okay, within 3 days thereafter. And the trial court is directed to fix the hearing and dispose of the matter
The
finally
Exhibit notice of motion.
by the 7th of June.
Till 7th, till then my
Six.
statement be recorded that the time can be.
No, there's no kind of answer. This time maybe.
That is what I'm
I
saying.
Till the
think
7th of
under the context.
Till the dispose of the matter till the 7th of June 2023. As far as the para Roman 4 of the order is concerned,
First part.
the
This is first.
injunction that was to come into effect from 25/5/2023 is extended till
So may I say the injunction for the current outlet?
yes.
It is specifically
No,
stated.
no,
Para
what?
No, but
Whatever-
para the last part is.
Yes, yes, that may
The
be
last part
recorded.
continues of that.
No, that in the beginning I will say that
That's why
this time
only the extension of the
the-
date.
Allow
Agad
court to
ekle
pass
agad
the-
paragraph. The learned advocate for the petitioner has submitted that the petitioner does not intend to open any new outlets, any new outlets or properties or resorts, etc. under the
Disposal
impugned
of the-
mark till disposal of the
Interim injunction.
interim injunction application. એ આગળ લઈ લો. અને પેલું છેલ્લે disposal
That may be
is extended till
disposal of the by party and your lady.
Only my humble concern is that if the ladyship sees the para code, it has specifically mentioned at the time limit insofar as the existing property being provided at so and so is
Yes.
concerned is effect from 25th. So only
I
which may be
say no,
extended
no,
till 7th June, that your ladyship
This
knows.
may be extended till disposal. Why?
At disposal 7th June.
7th June may finally be disposed of by 7th of June.
Then why I say
Then you
no,
can
but-
ask them to request
Exactly.
extend.
No, then that may be
No, it will be disposed of. It is not
Very well.
Very well, then.
disposed of finally on 7th of
When your
June.
ladyship may say, when your ladyship is saying that each check has to be disposed of peremptorily on 7th. It has
It
to
will
be
be
disposed of
disposed
peremptorily on
of.
7th.
Why do you
Then
have
let
such
it be
doubt?
extended, my lord, till fine, suppose it is.
No,
disposed
then-
before two. That's the only thing. That is our my practical experience before the court. That's
But
all.
I'm sure
That is
It
all.
will be disposed of
Exactly.
The
before
court,
the-
trial court is not powerless to extend that.
No, it's not, then it should come into that. There
It
is
will be
no-
disposed of by the 7th of June. Right? That's
Till
it.
then it is extended.
આગળનું મતલબ.
The ladyship is extending that, the-
7th June.
I said,
it is extended. till-
yes, the order is this way, and also that you are not going to open any new
Yes, yes, yes. that
resorts or anything. Order కోసం
Say number 2, AO 106 of 23, TA 1 of 23,
I
etc.
request man of the direct service, maybe they may take the direct
direct
service.
service permission.
Because they are the
Direct
for the
service.
claim.
Certainly,
They
very
may
very
apply before the court. I'm. My lord, before my learned friend ladies, my lord, your ladyship may observe, this is without prejudice to all rights and contention of the
Oh, that's
party.
right.
One second.
It is that.
Just a minute, every time you should not disturb. Without
Not
prejudice,
gone into the merits of the case and without
Yes, that
prejudice
is
to
correct.
all
the-
rights and contentions available under the law.
Yes.
court has said not.
And the order may be passed without being influenced by the ex parte order also. That may also.
No. This court has not gone into the merits. You
Yes,
go there and
very
you
good.
discuss how much
Okay,
you want
That is
there.
correct.
Say number 2.
In this matter, my lord, the other mode is not opted by the other side of availing a benefit of order 39 rule 4 for variation of occupied. Here the matter, my lord, date may come the before this. honorable.
Yes, that order below exhibit 37 and 38 is
30,
extended.
That is under 39 rule 4.
Hmm.
Wherein the exhibit 5 was confirmed, my lord, and thereafter after 1.5 years.
39,
Made an
38.
application to that and the honorable court earlier.
On which page is your application? Which was extended till
Look,
for the next 7 days?
please, my lord, that is
with CA also and with AO also. AO on last page, my lord. And page 298,
290.
290. And my lord, this is the latest order further extension of that is extended till today.
Till today.
Yes, not till yesterday, I'm sorry.
That is what, yes,
Till
it was stayed for 15 days
thereafter this is not.
on the 1st of May.
Because before the circulation was granted, the coordinate plans requested to go to there and get it extended. And
Yes.
that's how we get it extended.
Here you'll have the, it will have the application, this to admit, and then it will say that the petitioners have prayed for. This A, B, C, D, E, F. Steady expression. Next paragraph, learned advocate for the petitioner, Mr. So and so has stated that the order passed below, exhibit 37 and 38 by the learned trial court has been stayed till today. And the petitioners have to be protected. Hence, in view of this same, in the interest of justice, the petitioners have to be protected. The stay is extended. Exhibit 37 and 38 is extended till next date. Extended till next date, whenever it comes up for hearing.
Exhibit 37, 38 is already disposed of.
Then why are you coming here with the stay?
That order is stayed. Operation.
So that only, the operation of the order passed below 37 and 38, that is what you want, no?
Correct, my lord, but the.
Yes.
This matter is required to be posted for some day here and on.
Yes, that it will come in, so till then you are protected. Whenever it comes, maybe it will come up in June or July.
Wherever, Milord may,
Petition, and then it will.
Milord may fix up some date, Milord, for stand over to somewhere.
Okay, stand over to July, 3rd of July.
Lost it.
Okay, number 3, petition 9206 of 23, petitioner, relative.
As stated yesterday, there is a huge and rampant aggressive demolition drive which is being undertaken in Dahod city. Approximately by now 500 shops are demolished. Even some of the religious monuments are demolished, and so far as the property of the petitioner is concerned.
There are
My
two
lords,
matters. There are two matters of Dahod.
Yes,
that
say number 4 also.
Caveator is there
Stand at a different footing.
on a different footing,
Third and fourth.
in which there is no caveator.
No.
However, my learned friend appears for Dahod Nagar Palika, Mr. Purohit. There is a demarcation over the said property by the raid mark, which my lord would find at page number 76, that has been done on 15th of this month, May 2023. Page 76, if the Honorable Court would see this red arrow, they have come to the place by saying that
You put
have
here
to-
one black and white and then you ask me to see red.
I'm extremely sorry. This should have been,
Where is the arrow?
that one should be in the file of my lords. I'm extremely sorry for this. And Milord, they have orally said that.
Where is the arrow?
I just pass it over to the Honorable Court again.
खाली mana त्याथी बताए, just show me.
This, they say that you have to demolish.
Oh,
The
this.
passing from,
okay.
this has been done recently on 15th of May. We have immediately approached the authority. with a request page 74. Around 17/5 we have approached the authority by stating કે અમારી જમીનમાં ડીમાર્કેશન કરવા માટે પેજ 74 and 75 જય ભારત સાથે જણાવવાનું કે સો એન્ડ સો ના અરજ કરીએ છીએ કે હું દાહોદના રેવન્યુ સર્વે પ્લોટ નંબર 11 વાળી જમીન જે માલિકીની હોય વખતો વખતેની તબદીલ બાદ 2003 માં અમોએ સો એન્ડ સો પાસેથી વેચાણ દસ્તાવેજથી 2003-4 માં લીધેલ છે. ત્યારબાદ મિલકત સિટી સર્વે રેકર્ડ તથા અન્ય રેકર્ડ અમારી માલિકીમાં ચાલે છે. આ જગ્યા પર અમોએ ધાર્મિક મસ્જિદનું બાંધકામ કરેલું છે જે 2007 માં રેગ્યુલરાઇઝ કરેલ છે. દાહોદ શહેરમાં ચાલી રહ્યા ડીમાર્કેશન તથા ડિમોલેશનની કામગીરી દરમિયાન આક્ષીને અમારી માલિકીની જગ્યામાં ડીમાર્કેશન કરેલ છે. તો આપને અરજ કરીએ છીએ કે અમારી ધાર્મિક મસ્જિદ લોકોની ધાર્મિક લાગણીઓને ધ્યાનમાં લઈને આગળની કાર્યવાહીમાં મસ્જિદ તથા લોકોની લાગણી ના દુભાય ધ્યાનમાં લેવા મહેરબાની કરશો. This is a representation which we have made. Now I just take my lords to the facts, my lord, that these two plots have been purchased by way of registered sale deed by the present petitioner from the persons whose names are mentioned. Now those registered sale deeds starts from page number 2, annexure A. But thereafter, this is done in 2003. Thereafter, so far as the property card is concerned, which is maintained with the city survey record, both the entries are mutated and certified by the authorities, my lord, concerned. There is so far as two registered sale deeds are concerned, but one is a house and the second is an open land. So far as the house is concerned, my lord, the mosque is there in the house. Thereafter, my lord, some dispute had taken place in respect of ownership of this final plot number 111, because this is a draft town planning scheme of 1977. And therefore, my lord, there is an order which has been passed by the state government in the year 2008, which my lord would find at page number 48. As the dispute regarding ownership of three final plot in this town planning scheme has taken place, the state government has passed an order, page 48, you know, it's a short order I read, that town planning officer, town planning scheme number 1 and 1, first varied with liquidated so and so requested to appoint competent officer under provisions of so and so for the purpose of deciding the ownership of plot number 100, 109 and 111. And therefore, town planning officer, I'm sorry, not the town planning, the competent officer was directed to be appointed. In pursuance of this, my lord, the deputy collector came to be appointed as the competent officer, and page 49 is an order, which is dated 4/11/2009, by which the ownership came to be decided. હુકમ દાહોદ નગર સેવા so and so દ્વારા મંજૂર થયેલ છે, જેમાં યોજનામાં ફાઇનલ પ્લોટ નંબર 85 થી 115 થી નવીન જુદા જુદા હેતુ માટે નગરપાલિકાને સાંપ્રત થયેલ છે. So final plot number 100 બાદ માટે 109 green space and 111 green space. We are concerned with final plot number 111, which was reserved for green space in the draft town planning scheme. દાહોદ નગરપાલિકાએ નગર રચના યોજનામાં ગ્રીન સ્પેસ માટે પ્રાપ્ત થયેલી જમીનનો હેતુફેર કરવા કાર્યવાહી કરેલ છે. નગરપાલિકા દાહોદે 85 થી ફાઇનલ પ્લોટ નંબર 111 ના હેતુફેરનો ઠરાવ કરી ગ્રીન સ્પેસમાંથી આ જમીન કમી કરી રહેણાંક હેતુ માટે નક્કી કરેલ છે. સરકારશ્રીના અર્બન ડેવલપમેન્ટ અને અર્બન હાઉસિંગ ડિપાર્ટમેન્ટના નોટિફિકેશન 18/10/2000 થી ફાઇનલ પ્લોટ નંબર 111 કમી કરેલ છે. So by variation in the said scheme, 111 was deleted from green space. અને ફાઇનલ પ્લોટ નંબર 111 માટે નગર રચના યોજના એક હેતુફેર થતા આ જમીન રહેણાંકના હેતુ માટે નગરપાલિકાને સંપ્રાપ્ત થયેલી છે, જેથી પ્લોટ નંબર 111 ટાઉન પ્લાનિંગ અને અર્બન ડેવલપમેન્ટ અધિનિયમની મુજબ દાહોદ નગરપાલિકાની બને છે. ફાઇનલ પ્લોટ નંબર 111 માં હક ચોકસી કરતા સિટી સર્વેના પ્રોપર્ટી કાર્ડ મુજબ નીચે જણાવેલ કિસ્સાઓએ રજિસ્ટર્ડ દસ્તાવેજથી આ જમીનના પ્લોટો વેચાણ
That is, wait, just, where is that what you're reading? 50A, 50B.
Yes.
Do you have the type copy?
No, I don't have the type copy, but it is not before that description of the 10 persons.
Yes, it's, there's nothing here like that.
Then my lords,
GT plot નંબર 111 ટાઉન પ્લાનિંગ અને અર્બન ડેવલપમેન્ટ અધિનિયમની કલમ 46 મુજબ દાહોદ નગરપાલિકાની માલિકીની છે. And
Yes.
then the table.
then my lord, there are other 3 lines. Final plot number 111 માં હક
It's
ચોકસી
not
કરતા.
here. It's not here.
Like just this This is the original one.
Okay, so final plot number 111 માં હક ચોકસી કરતા
Yes. હક ચોકસી કરતા
આ લોકોએ જમીન વેચાણ રાખેલ છે, પ્લોટ
વેચા
વેચાણ રાખેલ છે.
અને તેઓ હાલમાં પ્રત્યક્ષ કબજો ભોગવટો હોય તેઓની માલિકી હક ધરે છે. So we are concerned with plot number 20 અને 19. So Salmaben Patrawala and Abbasbhai Ghadiari were declared as the owners in plot number 2019. And Anya Vigat, if the Honorable Court just have a look, Vechan Daudi Vora Jamat, Vechan Daudi Vora Jamat. Because this had taken place in the year 2003 and 2004. Registered sale deeds are of the year 2003 and 2004 so far as the present petitioner, that is Daudi Vora Jamat Masjid is concerned. So this has been decided, my lord, by the Deputy Collector way back in the year 4/11/2009, whereby the ownership is declared to be of the private persons. So there is no dispute in respect of the ownership of plot number 19 and 20. However, Dahod Nagar Palika continues, my lord, to claim that they are the owners of the said plots. This order has not been challenged by any person. So even in the property cards, our names are my lord mutated, and that my lords would find at page number, starting from page number 26. I take my lords, my lord, to page number 41. Two entries which are Manjur in 2004, 41 first two entries of the registered sale dates. And then, my lord, even the names of the legal heirs, page 45, have also been mutated in the revenue, in the city property card in the year 2014, which is at page number 45. 41, Lord, are two entries. Arashdar Jainuddin Mohammad Hussain Parawala ની અરજી તથા ઇન્ડેક્સ નંબર so and so 11/7/2003 થી આપના સલમાબેન અબ્દે અતિ પત્રાવાલા ખાનગી પ્લોટ નંબર 20. And then there is an entry of ખાનગી plot number 19, which is at Milord 31/7/2004. Daudi Vora, Anjum and Mohammadi Masjid. The second column, if the Honorable Court just have a look. So there is no dispute in respect of this ownership. Now what had happened that page 54, even in the year 2009, our fault is that I'll be very, that this house was already there. We have started masjid. This is for Rehna purpose. So at the most, the case against me is that I have not taken the permission for conversion of the use of the land. Because this was for the Rehna purpose and the masjid is going on, and this masjid is started from the said building. So at the most, my fault is that the hetu fair permission might not have been obtained. This is again a registered work property. I will not entering into the same that even before taking demolition, right? Or before demolishing any property which is a Waqf property, Waqf board is to be consulted. There has to be a prior permission of the Waqf board under section 91 of the Waqf Act, 90 and 91. And then page 54 may be seen. But even there is a letter by the deputy collector to the chief officer. ઉપરોક્ત વિષય જણાવવાનું કે આ કચેરીના હુકમ 4/9 ની જમીન નગરપાલિકા સંપ્રાપ્ત થયેલ હોય માલિકી તરીકે નાહોદ નગરપાલિકાને ઠરાવેલ છે, પરંતુ આ જમીનમાં સિટી સર્વે રેકર્ડ મુજબ 10 ઇસમોને વેચાણ હકે અને હાલમાં પ્રત્યક્ષ કબજો હોવાને કારણે તેમના મિલકતનો હકદાર ઠરે છે. આ કબજેદારોનું અનધિકૃત બાંધકામ નિયમોનુસાર નિયમબદ્ધ આપની કક્ષાએ કરવા પાત્ર થાય છે. આ સંદર્ભે દાઉદી વોરા જમાતના ટ્રસ્ટીશ્રીએ બાંધકામ નિયમિત કરી આપવાના રોજ અરજી કરેલ છે, જે નિગાહે ધ્યાનમાં લઈ અનધિકૃત બાંધકામ સરકારશ્રીના નિયમો મુજબ નિયમિત કરી આપવા કાર્યવાહી 30/30 કરી રિપોર્ટ કરવા વિનંતી છે. Then, my lord, there was an application for regularization under GRUDA of the year 2013, which was not considered on the ground that the ownership is of the Nagar Palika. However, the fact remains, page 63, that in the year 2007, the Nagar Palika has already recovered construction charges in respect of the so-called unauthorized construction by recovering the amount to the tune of rupees 21,050 and 13,000, which my lords would find at page number 63. This is a letter written by the present petitioner to the chief officer along with the receipts which were issued in the year 2007 of recovering of these charges, construction charges. So and so જણાવવાનું કે નગરપાલિકાની હવે અરજી દફતરે કરવામાં આવેલ છે. ઉપરોક્ત બાબતમાં વધુમાં જણાવવાનું કે પહોંચ નંબર સો એન્ડ સો ને પહોંચ નંબર સો એન્ડ સો ના બાંધકામ દંડ પેટે તથા દ્વિતીય પહોંચના બાંધકામ આકરણી ચાર્જ પેટે આપે વસૂલ કરેલ અને તેની પહોંચ અમોને આપેલ છે અને આ સાથે બંને પહોંચ ઝેરોક્સ સામેલ રાખેલ છે. તો આપ અમો પાસેથી બાંધકામ ચાર્જ અને 2007 માં વસૂલ કરેલ હોય અમોને મોહમ્મદી હસીન મસ્જિદ નું બાંધકામ નિયમિત કરી આપવા આગ્રહભરી નમ્ર અરજ છે. And then page 64, my lord would find two receipts of different amounts whereby my lord they have recovered this construction charges. Now
Where
for
does
the-
it say construction charges?
my lord,
Watch
page
my looking.
64,
Does it say that it is paid
I'll
towards
just take,
construction
I'll
charges?
just check. Bandhkam Dand, if the honorable court would find 64. 21,815 ની receipt છે 1/2007. My lords would find before the date 1/3/2007 Bandhkam Dand. And Bandhkam Akarni Saru, second receipt my lords would find Bandhkam Akarni Saru. So they have also started assessing the property and the construction put up upon the land in question, and they are recovering this all assessment charges from the year 2007 from the said petitioner. So these are the two receipts on which we relied upon in the year 2015 by saying that Bandhkam Dand.
These are only the two receipts that
Two
you have paid.
receipts, yes.
Besides this, nothing else has been paid.
No, but then this is the only thing which is my lord, that, and apart from that, my lord, now if my lords would come to page 65, now what is their case in the year 2018? Their case is that, my lord, again they are my lord, proceeding on the false premises. Final plot number 111 વાળી જમીન ટીપી સ્કીમ દાહોદ નગરપાલિકાને મળેલ છે. જે જમીન ટીપી રેકર્ડના બી4 મુજબ ગ્રીન સ્પેસ હેતુની નગરપાલિકા દાહોદની માલિકીની છે. Green space is already removed. I have already shown to the honorable court by an order. They themselves have made an application seeking variation in the scheme for conversion of green space into Rehnak Hetu, and thereafter this order is passed by the deputy collector of declaring 10 persons as the owners of the land in question. In spite of that fact, they are issuing the notice in the year 2018 by saying that green space hetu માટે છે, that is already removed. Then again વધુમાં જણાવવાનું કે નગરપાલિકા દાહોદની માલિકી ફાઇનલ પ્લોટ 111 વાળી સદર જમીનમાં જોડતો 15 મીટર પહોળાઈનો ટીપી રોડની જમીનમાં દબાણ કરી રોડ સાંકડો કરી દીધેલ છે. So their case is that this is a TP road of 15 meters and you have made encroachment and you have decreased the width of the road by putting up the construction. જેથી તમોને જણાવવામાં આવેલ છે કે 111 ની નગરપાલિકા દાહોદની માલિકીની જમીનમાં તમોએ કરેલ ગેરકાયદેસર બાંધકામ તાત્કાલિક અસરથી દૂર કરી ટીપી રોડ તથા નગરપાલિકા દાહોદ માલિકીની 111 વાળી જમીનમાં કરેલ દબાણ 2010 દૂર કરી લેખિત જાણ કરશો or else the actions will be taken. I have replied this notice page 66 by specifically stating that and taking each and every contention that the deputy collector has already passed an order in the year 2009 whereby the private persons have been declared as the owners of the sale land. You have not challenged the sale order. In addition to that, we have also stated that we have purchased these lands by way of registered sale deed. This has been assessed by the Nagar Palika. The property card has been prepared and we have been shown as the legal owners of the said land in question. Thereafter, after filing this reply, no action has been taken, no order has been passed by Nagar Palika. Nothing has been done. So it is presumed that they were satisfied with my reply and they have closed the proceeding. However, my lord, recently, they have again started under the, my lord, guise of developing this city as a smart city. And by not giving me any notice, by not giving any details, my lord, for which, my lord, they want to now take the action of demolition of the said property. They have, my lord, demarcated my property. In addition to that, my lord, I'll take my loss to other two documents, page 72 and 73. These are the resolutions passed by the committee as well as, my lord, the chief officer Dahod Nagar Palika, whereby they themselves have decided to make a proposal for variation of decreasing the width of the road from 15.20 meters to 7.5 meters. Page 72 and 73, I'll read it, my lord. મ્યુનિસિપલ સદસ્ય શ્રી શરદભાઈ દેવજીભાઈ ચૌહાણી મ્યુનિસિપલ સદસ્ય સોએન્સોના સાથે ચર્ચા વિચારણા અંતે સર્વાનુમતે ઠરાવ કરવામાં આવે છે કે એસટી સ્ટેન્ડની પાછળના ભાગે ફાઇનલ પ્લોટ 111 ની ઉત્તરે એસટી ડેપોમાંથી નીકળવાનો ટીકરી સ્કીમ હેઠળ 15.20 મીટરનો રસ્તો રાખેલ છે. આ રસ્તો ઠક્કર ફળિયા તરફથી આવતો ટીકરી સ્કીમના 10.70 મીટરના પહોળાઈના રસ્તાને મળે છે. આ 15.20 ની પહોળાઈનો રસ્તો ફક્ત 38.50 મીટર લંબાઈનો છે અને આગળ જતા રસ્તાની પહોળાઈ ઘટી જાય છે. સળંગ એક સરખી પહોળાઈનો રસ્તો નથી, જેથી એસટી કમ્પાઉન્ડ વોલથી જે 15.20 મીટરનો રસ્તો રાખેલ છે તે રસ્તામાં અન્ય ધાર્મિક બાંધકામ આવે છે અને લઘુત્તમ ફોર્મની ધાર્મિક લાગણીને ઠેસ પહોંચે તેમ છે. તો આ રસ્તાની પહોળાઈ 15.20 મીટર ઘટાડી 7.50 મીટર રાખવામાં આવે તો કોઈ વાંધા હરકત થાય તેમ જણાતું નથી ને ત્યાંથી ફક્ત એસટી અવરજવર થવાની હોય, જેથી આ રસ્તાની પહોળાઈ 7.50 મીટર રાખવા નગર રચના યોજના નંબર 1 માં મૂળ રચના અને શહેરી વિકાસ અધિનિયમની કલમ 71 અન્વયે સ્કીમમાં વેરિએશન કરવા મંજૂરી આપવામાં આવે છે તથા તેને મંજૂરી આપવા બોર્ડને ભલામણ કરવામાં આવે છે. Then there is another resolution by board, page 73.
ભલામણ સર્વાનુમતે
મંજૂર કરવામાં આવે છે. જે આગળનું resolution છે that has been sanctioned by this committee, my lord, the board, અને સર્વાનુમતે ભલામણ કરવામાં આવે છે કે this road does not require width of 15.20 meters and this can be decreased for 7.5 meters. So by these two resolutions, my lord, what the impression is gathered is the variation scheme under section 71 is already, my lord, submitted by Nagar Palika to the state government. We don't, at present, my lord, we are not even allowed to make or give any application seeking any information in the Right to Information Act. Because the committee is formed, my lord, for demolition of so many properties, we are not even allowed to ask for any information. So at present, we don't know that what is the present status of these proposals seeking variation of the road. Their case at present is that we want to widen this road and therefore we want to go for the demolition. However, my lord, now apart from all these facts, the question remains, my lord, that the municipality wants to exercise the powers under section 185 of the Gujarat Municipality Act. Whether they can do it without giving me any opportunity of being heard. At present, I am before this honorable court, my lord, by making my lord, ever so old that how this demolition drive is being carried out by this authority. Most of the persons are not even issued notices, and 500, approximately 500 shops are raised. Overnight, my lord, even the religious monuments are being raised. And in that, my lord, I am coming before this honorable court only with a request that before taking any action against the petitioner, the principles of natural justice are required to be followed. They must give me a notice. I must be given an opportunity to represent my case before the authority because I have already done so in the year 2018. And thereafter, they have not taken any action. And then they are required to pass a reason order, and then I have a chance to even challenge that order, which may be passed against me, or by considering all the submissions which I make, they may consider my case also. But now, at present, just asking me to demolish orally without giving me anything in writing, will prejudice the constitutional rights of the petitioner, and therefore I am before this honorable court. Now placed on record because several orders passed by this honorable court because Several petitions have been filed before this honorable court so far as several Nagarpalikas are concerned, seeking to exercise their powers under section 185 of the Gujarat Municipalities Act. And yesterday only in other matters, several judgments have been, my lord, shown to my lords, my lord. And I'll be also relying upon page, my lord, one of the several orders, my lord, are placed on record, page 98. And this is more particularly regarding the powers of the municipality and corporation, and whether the corporation can, my lord, exercise the powers of demolition without giving opportunity of hearing to the person. Page 98, my lord, this is a 1995 to GLR 974. And the court has observed, after considering the orders and the judgments passed by the Honorable Supreme Court as well as the Division Bench of this Honorable Court, at page 103, paragraph number 16, the court has not laid down general principles of universal applicability, that the principles of natural justice are not required to be observed in all cases. So this was in pursuance of the argument which has been canvassed by the advocate of the Nagarpalika that section 185 of Gujarat Municipalities Act does not specifically provide for giving any personal opportunity of hearing to the petitioner. If my lords would just have a look at section 185 of Gujarat Municipalities Act. Whoever is whether I am with my loss, whoever in
Yes.
any area after it has become a municipal borough shall have built or set up, or shall build or set up any wall or any fence, rail, post, stall, veranda, platform, green step, or any projecting structure or thing, or other encroachment or obstruction, or shall deposit or cause to be placed to be deposited any box, bale, package, or merchandise on any other thing in any public place or street, or in or over or upon any open drain, gutter, sewer, or aqueduct in such place or street shall be punished with fine which may extend to 50 rupees and with further fine which may extend to 10 rupees for every day on which such projection, encroachment, obstruction, or deposit continues after the date of first conviction for such offence. Then this 185(2) comes in picture. The chief officer shall have power to remove any such obstruction or encroachment, and shall have the like power to remove any unauthorized obstruction or encroachment of the like nature in any open space, not being private property, whether such space is vested in the municipality or not. Provided that if the space be vested in the government, the permission of the collector shall have first been obtained. The expense of such removal shall be paid by the person who has caused the said obstruction or encroachment, and shall be recoverable in the same manner as an amount claimed on account of any tax recoverable under chapter 9. So the powers which are purported to be exercised by the chief officer under section 185(2). So the argument was advanced that the statute does not provide specifically for giving an opportunity of hearing before exercising the powers by the chief officer under section 185(2). And in light of that, the Honorable Court deals with the same, paragraph number 60. The court has not laid down general principles of universal applicability, that the principles of natural justice are not required to be observed in all cases. This judgment of a division bench of this court cannot be read so as to lay down any principle contrary to the principles laid down by the Honorable Supreme Court in the case of Olga Tallis. It is not permissible to read this decision in a manner which may lead to conclusion inconsistent with the law laid down by the Supreme Court. Whenever it is possible to read a decision of this court harmoniously with the principles laid down by the Supreme Court, the decision has to be read in that fashion. It has to be presumed that this court would never intend to lay down any principles of law which may run counter to law declared by the apex court of the country. The Honorable Apex Court in the case of so-and-so laid down that the power conferred upon the Commission will be exercised sparingly in case of urgent emergency which with no delay. In all other cases, no departure from the rule of body alterum partum could be premused to have been intended by the legislature. The Honorable Supreme Court has further observed that hearing may be given individually or collectively depending upon the facts of each situation. Departure from this fundamental rule may be presumed to have been intended by the legislature only in the circumstances which warrant such departure. The Supreme Court has laid down the principle that such circumstances must be shown to exist when so required. The burden to prove the existence of such circumstances is on those who affirm the existence of such circumstances. As observed herein above, no such circumstances have been shown to exist in these cases. By producing contemporaneous record, of course, an attempt is made to justify the action by making certain averments in the affidavit in reply, but it is an admitted position that before acting, no reasons have been recorded. There is no contemporaneous document indicating that existed emergency which brooked no delay and the situation demanded dispensing with the observance of principles of natural justice. Therefore, on the basis of averment made, I skip that. I skip also paragraph number 18. 19, in the case of Bhavnagar Municipal Corporation versus so-and-so, a division bench of this court has approved the principles laid down in Nehru Marg Cabin Association. It is observed as follows: even trespassers cannot be removed without affording an opportunity of being heard and without giving sufficient notice, so as to enable them to remove themselves from the place alleged to have been encroached. The observations made and the conclusions arrived at in the case of Nehru Marg Cabin Association are eminently just and proper. We are of the opinion that in absence of prescribed procedure under any act or rules, the procedure indicated in the opposite decision of this court is required to be followed by the executive authorities before removing the person who might have allegedly encroached upon the land of the public street. The procedure indicated in the case of Nehru Marg Cabin Association is as follows. The respondent authority shall not take any action of removal of the petitioners from the business premises occupied by them without affording them an opportunity of being heard. Such opportunity of being heard could also include a notice in writing to be served upon each of the occupants. Then, Lord B, the occupant consent shall be afforded an opportunity of leading evidence in response to the notice. The occupant consent shall also be afforded an opportunity of being heard in person either by himself. In case the respondent authorities, after the inquiry as stated herein above, come to the conclusion that the occupant consent is required to be removed from the place and any such decision adverse to the occupant is taken, the same shall not be implemented for so and so. The order will be passed in so and so. This is particularly in light of section 185 of Gujarat Municipality. I will not burden my lords by citing no judgment. And the Honorable Supreme Court has gone to the extent that the notice has to be specific. What specific area, the measurement of the area, and everything has to be stated in the notice. So the notice, my lord, has to be preceded before taking any action. They will say we have issued notice in 2008. I have replied, they have not passed any order. So before passing any order in that, my lord, notice or without issuing new notice to me, but my request to the Honorable Court is that no coercive action may be taken. But at present, we are facing imminent, danger of demolition. And that is, the averments, specific averments have been made that how in the night hours, in the, even in the morning hours at 4 a.m., 12 a.m., they are taking this action against the residents of this Dahod city. And in that light of matter, I am before this Honorable Court, I'll be making a request that let them produce on record, that what had happened to that variation scheme which they have themselves have proposed to the government. And if that scheme is under consideration, they cannot take any action against it. And at present, we have not been allowed to enter. Enter the office, ask the information of this corporate Nagar Palika.
Acha, office, their office.
Of their office, we are not been allowed to give an application. They are not providing any information to us. And these are the documents. On the face of the order of 2009 passed by the Deputy Collector, by which we are declared owners of the said property. But whether they can do or take any action against us without, providing us an opportunity of hearing. We are not the trespassers. We are not the encroachers. We are the registered legal owners of the land in question.
Yes.
And in that, I have come before this Honorable Court. I will be making request, to, protect us, before taking any action against us. I have tried to give the copy to my learned friend, but
No, in the morning I just, because in the another matter, I was on KBL.
So in the morning, my lord
Yes.
suggested that there is one more matter. So I think, I'll take.
You are for Daud Nagar Palika. And you are for the state.
Revenue officers. Multifold developments have been raised before this honorable court today. At the best, my humble submission is that these governments are mere impeachments.
No.
I had a word with the revenue officer in the morning, just before the court commenced, my lords. As on today, the structure stands. It is a mere apprehension.
But
of
why
the
that
petitioner.
line, red arrow?
My lords, that is the question. But as on
Who
today,
has made that arrow? The Nagar
The
Palika.
officers of Nagar Palika, they have come.
it is by instruction, sir, city survey office has demarcated all the properties or wherever this demarcation is, this is where the demarcation is, it is encroachment over the public road. My learned friend made,
Yes.
I may not, because I am not having the paper, but what could be heard out from the submission is, it is not denied that there is an encroachment. Lordship had referred my learned friend referred that there is an encroachment.
But no notice has to be given. You just mark it like that and then come and you see. And what about their their submission? You had given a notice in 2000. But the authority decide on that.
I have to, certainly, Lordship, I have to take instruction on that because this was of 2018 and what my learned friend now submits that the proposal of variation.
Variation, okay, yes.
I do not have any
That is-
knowledge
that is
any
another-
proposal was even, I don't know, any such, it has been materialized. Here is the question where for a smart city, the roads are to be widened up. The encroachment over the public road are to be removed. So there is no question that it would be from 15 meters to 7.5 meters. So in my humble submission, I have no instructions that any such proposal is materialized for sending the proposal to the state government under section 71 for variation. So
That is
the
one
part.
issue. But what about this? Should a notice not be given? Okay, earlier notice has been given, not decided. Had you decided and said, yes, okay, we don't
For that-
consider.
For that, Lordship, I have to take that what happened to the 2018 notices and
And at least an opportunity of hearing.
I have to take in other cases. I am absolutely instructions. There is no reason to believe that this will not be issued again. The process has not been taken yet for any such demolition.
Why-
Now, the law is clear, my lord. The learned friend has brought out the law. There is no reason for the authorities to not follow the law. If there is going to be demolition, there will be a.
That is what is there, that you should at least give them,
the
they should
apprehension, my
know
lords, is
that-
not very well founded, is my submission today.
no, then tell me the reason for the mark. That is my query.
I quite see, but then my
Some
the
government
Nagar Palika,
official
I-
comes and marks your house and a lot of houses.
Instructions are this is done by the city survey office. Demarcating the proportion of an encroachment over the public road.
But is there demolition undertaken now?
As far as the property, the demolition.
As not as far as the
taken,
property, in the town, in the,
it is only where the public road is there and if the encroachment is over the public, extent to which it is an encroachment over the public, that is demarcated, Lordship.
okay, so that is what is being done.
Yes, Lordship.
That you are demarcating, you are marking it.
To the extent which is an encroachment over the
Yes,
public.
okay,
road.
whatever it is.
Please,
So
ma'am.
whatever is you
Correct.
feel, if you say that this is,
For an instance, my learned friend submitted that there is some house or property. Admittedly, there are correspondence to the effect that they have also requested for regularization. The
Yes.
assessment which is done, that is, Lordships are aware, it is for usage. It doesn't give any ownership.
yes,
So what has been demarcated is only the proportion of a property which is admittedly an encroachment, which comes.
no, but now you have to tell it to them. No, look,
Yes.
this is your encroachment.
So this,
When will you tell it?
so now.
When you
that
give
my
them a
learned friend
chance.
suggested.
First,
Yes.
you say
If it is
that,
anticipated that we will be carrying out the process, we will issue a notice. There is no reason to believe today that such notices will not be issued. I'm making a statement. that if
so shall we say that?
My lords, if my lords are
Yes.
inclined to issue a notice, my lords may observe that, or if my lords are enforcing that appropriate.
Yes, that,
process of law, maybe The process of law has to be undertaken before such demolition. If allow that to are issuing a notice.
Give them full opportunity of hearing, let them put up their case. Opportunity has to be given.
Whatever the compliance is to be done by landed person is there. Because there is no reason that in other cases also the notices were given. So in this case, before undertaking that apprehension to be approved for demolition, notice will be given. In fact, my lord, in the city, wherever if demolition has been undertaken, my lords, there is notice has been issued. So if it is to be undertaken, this final plot, it will be issued.
Okay.
Many of them have not come in. Most of the cases, no notice has even been issued. I'm not joining because I'm not representing.
No, let us,
Yes, I'm
we'll
not
take his
representing
record
them,
his
but-
statement saying that in case any action has to be taken, notice will be issued.
Appropriate process
And
of law
everything.
will be.
So the petitioner has filed the present petition under article. Under article is so and so of the Constitution of India, 22 to 6 of the Constitution of India. And has made the following the prayers. A, B, C, D. Mr. What is his name? You are appearing for the Nagarpalika, no? Your name?
Page 88, my lord, one of the orders in the similar line which my lord want to ask. Page 88, my lord, paragraph number 5. If I'll just assisting the honorable court, I give it to the honorable court. That,
Correct.
yes, so I'll just, my lord, pointing out, my lord, to assist the honorable court.
Okay.
Many such orders are placed on record.
So you are appearing for Dahod Smart City Development Limited? No.
I'll be for Nagar.
Chief Officer Nagarpalika. Mr. Your name?
Vimal Guru. I will be permitted to file my appeal.
Yes, permitted to file appearance and he's appearing for respondent number 5. What is his name? I don't know. Mr. So-and-so is appearing for the state. 1, 2, 3, 4.
At page 96 and 97 would be the identical types, the 96. 97 in particular. 185 notice was issued. Reply was given, no order was passed and the matter was pending.
Okay. His name, what is his name? Upon instruction from Srimati N.B. Ratnik, Mr. Sahil Trivedi, actually. Third, so and so on. Now we'll say that. Third learned advocate, what is her name? Her name. Here stated that submitted that the property of the petitioners has been demarcated with red arrows and large demolition drive has been undertaken by the respondents in Dahod.
If I may, just make a suggestion.
Without-
If our inclined may dispose of the matter with a mere observation that if any process of demolition is to be undertaken.
Yes, that is what we are doing. That is what we are doing. Not going into the merits. Not the demarcation and no notice has been served regarding any illegal construction on their property. The petitioners have also submitted that they are the owners, legal owners of the property, and they apprehend that without following the provisions of Section 185 of the Gujarat Municipalities Act 1963, their properties may be demolished. learned also has one instruction also has submitted that the respondents will follow the due process of law and serve the notices in case any demolition is required to be undertaken. We do not go into the merits of the matter, but hereby direct the respondents, Nagar Palika, to follow the due process of law and give an opportunity of hearing before taking any coercive action. And the petitioners must be allowed to put forward their case. The Nagar Palika shall give an opportunity of being heard to the petitioner and then pass a reasoned order. We are not giving any time bound limit. Okay. Only in case you intend to demolish or undertake any action, a notice has to be given and they have to be given a reasonable opportunity of being heard. We have not gone into the
And the order is to be passed by.
order to will be passed.
Yes,
Will
the
have
reasoned order has.
reasoned order have to be passed.
So that
Yes,
they may be-
reasoned order will have to be passed. This court has not gone into the merits of the case
Right.
and no opinion on merits have been expressed.
Faithful to. May I seek one indulgence if they take any adverse decision, then it may not be implemented for a period of 7 or 10 days.
That,
What
no, you put up, if you have a good case, you put it up before them.
We
They will-
have put it up,
Yes.
and they have.
No, now we have recorded both
Yes.
their statements saying that no, they will be given an opportunity.
My apprehension is that overnight everything will be done. That's the only thing, Lord, if they take any.
I think
adverse
they are both
decision-
responsible officers and they will,
If the court has directed that he issued a notice, they be heard.
yes,
That cannot happen overnight.
And after passing the order, which may come
And-
adverse to me.
he has already stated that upon instruction from the branch officer, they are not intending as of now to immediately undertake any demolition
I leave it to the.
without following the due
The-
process of law.
The record shows me not that they are in hurry to develop this city as a smart city. So they may do anything, my lord, and they have done so. The next phase, my lord, may not even they have raised the entire construction. So only request if they take any adverse decision, my lord, they may not be implemented for 10 days.
Notice has to be,
Because
That has to be
it is not done. Notice my own notice is done, no structure agreement.
and notice as per law,
Yes, sir, notice.
as per the provisions of law. You say now if you have gone and measured, then you say that 3 feet or whatever.
That's why the demarcation, so if they have any difference to say, otherwise they would not have. As my learned friend pointed out, this is the demarcation which would show that this is the portion which is demarcated as an encroachment over the street, and this is what we.
Again, this is not an encroachment. They want to widen the road. This is my property. They want to implement the town planning scheme. So this would not be an encroachment.
So that is,
Yes.
let them serve you the notice, give you an opportunity of being heard. Yeah.
Only
What
request
about the
if-
next?
If it can be considered, may not be implemented for 10 days.
No, not,
Any
no,
adverse
no.
decision.
no.
That has been done.
No,
by this-
the opportunity will be given. You agitate your case
I
there.
am highly
What about the next case?
Direct
You are
service, direct
Direct service connected,
grateful to her.
not gone into the merits. This next one is almost the same, in the same line.
No, this is the next matter.
Yes,
So this is slightly different in this way, that it is already demolished.
demolished.
Already demolished, the masjid is demolished. Without any notice.
So now what is the prayer?
Lord, at first I take your lordship through the prayers. Look, they are on page 19. Lord, the first prayer is to declare the action to be illegal.
and direct the respondent authorities to restore, which cannot be done at this stage, and there is no question. Second is also to the same effect. Because the third is compensation, which also presently is not the issue. The fourth is also to initiate civil and criminal proceedings irrelevant at this stage. Fifth is the only relevant one. Pending admission, hearing, and final disposal of the present petition, may be pleased to maintain status quo with properties of the petitioner bearing survey number 451 to 456, 5246, and 5246.
So which are the properties which are demolished? These are the
Masjid is demolished.
Where? Number?
452. Survey number 450, city survey number 452. Lord, let me take your lordship for 5 minutes so that it will be clear. Lord, this, if your lordship would go to first annexure B, this is the PTR. Page 56. I'm sorry, because I used the word annexure. We page 56. Nagina Masjid Lahore. Now, if your lordship would go to page 58, these are the city survey numbers. The first is mosque in survey number, city survey number 452. Shops in 451, 453. Open piece of land 454, 455, 456, 5246, 5247. There are other open pieces of land which we are not concerned with. These are the lands which we are concerned about. Up to 450, 5247. This is part of the PTR. Now, Lord, your lordship may go straight to page 134. This is the extract of the property register of city survey. 451, 453, 454, 455, and 456 are given here. The old survey numbers are also given. And the second last column, Nagina Masjid, not very visible. Title or title opposite, I'm sorry. Page 137. And your lordship may go to the last column of the typed copy. जूनो कब्जेदार कलेक्टर तारीख 6/8/23 ता हुकम की दुरुस्ती 23 એટલે 1923 6/8/23 નો થયું જ નથી 2023 1923 ની દુરુસ્તી. Your lordship may then go to 452 on the next page 138. It is there in the original law. 452 3684 Nagina Masjid 6/8/23 ના હુકમ की दुरुस्त. Therefore, in 1923, it is recorded in the name. Now, the lordship may go to the property register at annexure A, which is page 23. It starts at page 23. Your lordship may go straight to page 38. This is the city survey Lahore property register. Type copies on the next page. City survey number 452, Nagina Masjid, Muhammad Bhai, Walu Bhai, etc. Well, the date given of the mutation entry is 6/8/23. The typed copy is on the next. This is 452. 451 is also there, which is at page 35 and that's 36. Again, Nagina Masjid. So we are concerned where demolition has taken place is 451, 452, 453. 451 and 453 were shops and 452 was the masjid. And 453 is page 41. Now, notices are issued. Which is at page 66. Notices are issued on 25/4/2023 only to the occupants of the shops. Well, the law requires notice both to the owner and the occupant. These are notices to the occupants of the shop, not a single notice issued to the masjid. These are all with respect to one survey number 745A. Only. Thereafter, my lord, we apprehended, there was a reply given by that we are not concerned about it. We apprehended that the masjid will be demolished. Lord, page 112 may be seen. Other shops were demolished. This is the masjid which was in existence at the relevant time. But we apprehended the masjid will be demolished. The authorities said that you come before the authority and we will give you a hearing without notice. The Lordship may see page 8 of the petition. Page 7, there are 3 points. Therefore, on becoming aware of the same, petitioner, beneficiaries, and other local leaders and general masses rushed to the site, and demolition of place of worship is an emotive issue having large-scale repercussions. Thereupon, the petitioner and other beneficiaries showed documents which prove existence of the masjid at least since 1926. And pertaining to masjid and shops being waqf and waqf property, property cards, PTR, etc. But the respondent authorities nullified and refused to acknowledge the said documents and threatened to proceed further with demolition. However, due to volatile situation, the respondents agreed to arrange a meeting between the petitioner and others. But in the meeting, the respondents again refused to acknowledge the documents and instructed to remove all religious books, Quran, and other religious articles from the masjid till Friday, 19/5/2020. And that after Friday prayers, masjid will be demolished. Annexed here to and marked Annexure A are the affidavits of the petitioner and others declaring on oath the events as to place of threatened demolition. The above mentioned, I'll take a lordship through the documents, but I first let me finish this. The above mentioned demolition drive, which was carried out on 15/5, also reported in Sunday Daily newspaper on 16/5. That was with respect to the shops. So if you lordship want to go to the documents, that is at page 122. The affidavits are at page 113. They are all dated 19/5/2023. The first affidavit is filed by the trustee of the trust, who is the petitioner. Other affidavits are by others. But going back to page 8, the aforementioned work was carried out in lieu of the aforesaid on 16/5, the petitioner mentioned urgent listing of hearing before the honorable vacation bench of this court. However, the honorable vacation bench was not pleased to grant permission. Whereas since the masjid and the properties are waqf properties, and the demolition of the said waqf properties are in contravention of the statutory provision of the Waqf Act, the petitioner approached Gujarat State Waqf Board. Therefore, respondent number 6 Waqf Board wrote a letter dated 16/5/2023 to the respondent number 2 collector, requesting to suspend the process of demolition of the waqf properties of the petitioner trust in view of the statutory provisions of the waqf property. Annexed here to a marked annexure H is a copy of the said letter. So that letter is at page 120. And the request was page 125. Last 5 lines, જેથી સદર સંસ્થા સિટી સર્વે નંબર 451 એ 456 વાળી વકફ મિલકતમાં નથીના મસ્જિદ આવેલ છે. જે વકફ મિલકત જેથી સદર વકફ મિલકત દબાણ કરવા દૂર કરવા માટે કાર્યવાહી આપના પક્ષથી કરવામાં આવેલ છે તે સ્થગિત કરવા તથા સદર સંસ્થાની વકફ મિલકત કોઈ પણ જાતની ફેરબદલ કે તબદીલ ન કરી શકે જગ્યાના હાલની જે પરિસ્થિતિ તે નાખવા વિનંતી કરેલી છે. Then the lordship may go to page 9. In view of the aforesaid meeting was convened by the respondent number 2 collector, and thereby it was resolved that the respondent number 3 to 5 will provide hearing, produce the documents and decide further course of action. Therefore, on 19 by the petitioner who is advocate appeared before the respondent number 3 to 5, made submission that urged to suspend the demolition of the masjid inter area containing the demolition would be completely in contravention of the provisions of the Municipalities Act, the Waqf Act and the Places of Worship Act. It was also submitted that demolition would be in the breach of principles of natural justice. And the same was being done without following the procedure of law. However, no response to the said submission in the hearing was given. And in the dead of night on 20th April, around 4 a.m., the entire structure of the masjid came to be demolished by the respondent number 2 to 5 along with huge police. No notice. Only when we agitated, we were said that you come and we'll give you check. And this was demolished. Your lordship may go to annexure J. This was the masjid which was demolished. And it is completely demolished today. Lord, we are only saying that the status quo in respect of that land may be maintained, and we are only requesting for land bearing survey numbers 451 to 457 and 2 more pieces. That's all.
Sir, I'll submit this matter. Reply will be necessary from my side, from the state authorities, and from the Nagar Panchayat. Reason, certain facts which are being presented before my lord are not in its entirety.
You were the caveat.
Please, brother, I got it. I received the copy yesterday.
Yes.
I may have to, because half of, as far as the shops were there, this was under the municipality had issued the notice under 185. And the subject issue with my learned senior son is agitating. There is a committee formed wherein SDM is the chief of the committee, and this decisions is taken by the state authority projects. So the issue which my learned senior friend is now requesting for to maintain status quo for those survey numbers, that would come under the purview of the state authorities. This is a committee headed by the SDM who has taken the decisions. Nagar Palika, as far as the shops were concerned, notices were issued. They were on the public.
Shops.
And they were not issued to those shops. The notices are issued to other shops. So those are not in 451 and 453. No,
This is my humble submission. Notices are already produced.
no, they are not with respect to 451. They are
Therefore, a reply would be because it is not entirely what has been, and this was also mentioned. This honorable court did not deem it necessary even to grant circulation. This is how the matter, but here in my humble submission, the reply would be necessary. So as
So in your reply, they may maintain status quo. It's an open, it's a demolished area.
this would be, I didn't mean a thing. I didn't mean that principles of mental justice are not, they have not been heard.
As far as this is concerned,
Yes.
they say that no notices have been issued.
I may just submit this one. This entire exercise had started way back on 6th of May 2022. Because reason being, I do have a copy. I'll produce it with by European entity, but only for my lord perusal. If I may show, on advance copy from the concerned SPL. This is the Bhutan, this is the committee wherein the representatives were there. They were heard, adjournments were given. They were requested to give the proof as to how the masjid came in the occupation of such land, because
even yesterday, when I had a word with the authorities, I requested to provide me the revenue record. Because the revenue record, even before the commencement of.
Okay, so you can file your detailed reply,
It will be.
but till then, I think let it be as it is. Because what would happen is if you remove all the thing and make a road, then it
Even
would be,
otherwise, because
let this appeal also be decided.
apart-
Because they have, see, if you see their prayers, they are,
I can understand.
But other prayers will have to be at a final hearing stage.
Yes.
Only prayer I am
so
seeking
till the
today.
final, otherwise what would happen is the whole structure would change, no?
Development work would happen.
We'll do, you can,
In that case, simpliciter notice can be issued, matter may be kept on next week, itself will file our appeal.
but till then it will all be
Till then,
changed.
status to be maintained.
Till then status quo.
Reason be, my lord, reason be, if they were not heard, if nothing would have been done, because
That is what they are saying.
there is an order. And there's this.
No, no notice. See, not that.
Only.
You have to first issue a notice because the other notices are under section 185. You show me a notice under section 185. Do you have? Correct, Mr.
No, there is no notice, because let them show the notice.
Because who was present in that committee? You put up your case. So till then, we can fix it before the, after the,
I can only, my lord, make my case good, because only for a moment, if my lord may read this 90.
let me see. Sure.
19 may undoubtedly be heard. I'm not saying no.
My lord, the other dates are of different dates, starting from 6th of May.
But I'm not aware of any.
That is what is his case also. That they have filed the,
We made a representation.
they made a representation. That is what they are saying. It was his say also.
My-
That without being issued the notice, they themselves went there and they were this thing heard.
In
But
that case,
then-
only first page of my
Yeah.
documentation, first page. Which I have directly come to the 19th order, but if my lord may see the first page. In this communication of 19th, if my lord may see, total 6 members were there,
Yes,
comprising of STM.
yes. Okay, these, city survey, Mamlatdar, DILR,
Chief Officer Lao. If my lord will permit, I may read.
yes,
I'm sorry, my lord, since it is handwritten, I could not let it type. દાહોદમાં સ્માર્ટ સિટી યોજના હેઠળ 10 સ્માર્ટ રોડ ઉપર આવેલ દબાણ હટાવવાની કામગીરી હાથ ધરવામાં આવેલ હતી. બિરસા મુંડા સર્કલ નજીક સ્થિત નવીન વર્ધિત ધાર્મિક દબાણ બાબતે મુસ્લિમ સમાજના અગ્રણીઓ સાથે તારીખ 6/5/2023 રોજ મીટિંગ કરી નવીન વર્ધિતના પુરાવા રજૂ કરવા જણાવવામાં આવ્યું હતું અને માલિકી હક સાબિત કરવા નક્કર પુરાવા રજૂ કરવા જણાવવામાં આવ્યું. તારીખ 13/5/2023 રોજ મુસ્લિમ સમાજના અગ્રણીઓ ગ્રામ કચેરી આવી પ્રોપર્ટી કાર્ડની નકલ રજૂ કરેલ છે. તેમાં નગીના મસ્જિદનું નામ દાખલ થયેલ છે, પરંતુ પ્રોપર્ટી કાર્ડમાં નગીના મસ્જિદનું નામ દાખલ કેવી રીતે થયેલ અને કયા પુરાવાના આધારે દાખલ થયું તે અંગે રેકોર્ડ રજૂ કરી શકેલ નથી. તેમજ તારીખ 15/5/2023 અને તારીખ 16/5/2023 રોજ મુસ્લિમ સમાજ અગ્રણીઓ સાથે મીટિંગ કરતા તેઓએ માલિકી હક પ્રસ્થાપિત કરી શકે તેવો કોઈ પુરાવો રજૂ કરી શકેલ નથી. તેમજ આજરોજ મુસ્લિમ સમાજ અગ્રણી તારીખ 23 વકીલ શ્રી હાજર રહી નગીના મસ્જિદની માલિકી હકની અંગે મૌખિક દલીલો અને સુપ્રીમ કોર્ટના જજમેન્ટની નકલો રજૂ કરી છે, પરંતુ નગીના મસ્જિદ બાબતે મુસ્લિમ સમાજ દ્વારા દાખલ થયેલ હાઈકોર્ટની પિટિશનની મનાઈ હુકમ માંગણીની અરજીની સુનાવણી દરમિયાન હાઈકોર્ટના વેબસાઇટ માલિકી હક અંગે નકલ પુરાવા રજૂ થયેલ ન હોવાથી કેસ એડમિશનના લેવલે નકારી મનાઈ હુકમ આપેલ નથી. તેમજ તેમની દબાણની નોટિસ ન મળ્યા બાબતની દલીલ બાબતે અને અનધિકૃત કબજા બાબતે કોઈ નોટિસ આપવાની રહેતી નથી એવું કેસ દરમિયાન પૂર્વ ચર્ચામાં જણાવેલ છે. તેમજ કલેક્ટર સાહેબની સૂચના મુજબ ધાર્મિક દબાણોને લગતી ફરિયાદોમાં રેકોર્ડ તપાસી નિર્ણય કરવા બાબતે આજરોજ 19/5/2023 રોજ કાયમ ખરડો સિટી સર્વે પ્રોપર્ટી કાર્ડ અને અન્ય તમામ રેકોર્ડની તપાસણી કરતા નગીના મસ્જિદ અંગે કોઈ સનદ કે હુકમ મળી આવેલ નથી. તેમજ મુસ્લિમ અગ્રણીઓ તરફથી કોઈ સનદ હુકમ રજૂ થયેલ નથી, જેથી પુરાવાના અભાવમાં નિર્ણય લીધેલ કે નગીના મસ્જિદ દબાણમાં છે અને તેને તોડવામાં આવશે. આ બાબતનો નિર્ણય જાણ કરી મુસ્લિમ સમાજના આગેવાનોની મીટિંગ દરમિયાન જાણ કરવામાં આવી. મુસ્લિમ સમાજ દ્વારા હાઈકોર્ટમાં કેસ દાખલ કરેલ તેઓએ જે રજૂઆતો અને રેકોર્ડ રજૂ કરેલ તેના આધારે હાઈકોર્ટ દ્વારા મનાઈ હુકમ આપેલ નથી. તે જ રેકોર્ડ તેમને અહીંયા પત્રે રજૂ કરેલ છે. તે સિવાય અન્ય કોઈ પુરાવો રજૂ કરી શકેલ નથી, જેથી તમામ હાજર રહી મુસ્લિમ અગ્રણીઓ મસ્જિદ દબાણમાં હોવાથી તોડવામાં આવશે તેની મીટિંગ દરમિયાન જાણ કરવામાં આવી.
अन्य कोई मुद्दाओं की चर्चा નથી.
So who are all these people? They were your people? They were,
Beloved, let us see, can I have this class so that I can explain it? Beloved, અગ્રણીઓને બોલાવવામાં આવ્યા હતા 6-5 અને ફરી બસ.
no, but then somebody represented K.
1905 everybody represents, no doubt about it. But
I
your
got
lordship
it.
6-5 અને 13-5 બોલાવવામાં આવ્યા. પ્રોપર્ટી કાર્ડ આપવામાં આવ્યું છે. The authorities say કે notice required નથી. હાઈકોર્ટમાં ઓર્ડર નથી. હાઈકોર્ટનો ઓર્ડર રિજેક્ટ કર્યો છે એવું લખેલું છે. The lordship, let us see.
That was the submission made by, because there was no any representative.
The lordship can now see
What the advocate was
Look, I am producing the property card at page 20. Page 38. I am producing the property card. They are recording that property card માં 6-23 નો order અમે રજૂ નથી કર્યો.
But બે વકીલશ્રીઓ બી હાજર હતા. બે વકીલો બી હાજર હતા. અને you,
That appeared, I stored all the documents and contended that in view of this, you cannot proceed ahead with demolition. They said, we are not going to, they did consider the documents at all. And thereafter informed the all Muslims leader that we'll be taking up revolution. You just try to see to it that the peace and tranquility is maintained.
Lord, can I read now? Lord, let me read this whole paragraph. I'll be a little slow. Lord, your lordship may see midway on the first page. જેમાં નદીના મસ્જિદનું નામ દાખલ થયેલ છે, પરંતુ the very your lordship દાખલ થયેલ છે, પરંતુ પ્રોપર્ટી કાર્ડમાં નદીના મસ્જિદનું નામ દાખલ કેવી રીતે અને કયા પુરાવાના આધારે દાખલ થયું છે એ અંગે રેકોર્ડ રજૂ કરી શકેલ નથી. The property card is a revenue record. It's a revenue record. It shows, I am showing the register of PTR, which shows these numbers. I am showing the property card. Property card માં કેવી રીતે દાખલ થયું 1923 નું એન્ટ્રી. સાથે મીટિંગ કરતા તેઓએ માલિક કે પ્રસ્તાવિત કરી શકે તેવો કોઈ પુરાવો પ્રોપર્ટી કાર્ડ સિવાય બીજો શું પુરાવો હોય? પ્રોપર્ટી how it is entered in the property card in 6/23? How would I be able to produce such document? Then તેમજ આજ રોજ મુસ્લિમ સભાના અગ્રણીઓ સાથે તેમના બે વકીલશ્રીઓ એમ.કે. હકીમ અને બ્રજ અશ્વિન શાહ હાજર રહી નગીના મસ્જિદની માલિકી હકની સાક્ષી અને મૌખિક દલીલો અને સુપ્રીમ કોર્ટ જજમેન્ટોની નકલો રજૂ કરે છે. પરંતુ નગીના મસ્જિદ આ બાબતમાં મુસ્લિમ સમાજ દ્વારા દાખલ થયેલ હાઈકોર્ટ પિટિશનની મનાઈ હુકમ માંગણી અરજી સુનાવણી દરમિયાન હાઈકોર્ટના જજ સાહેબે માલિકી હક અંગે નકાર પુરાવો રજૂ થયેલ ન હોવાથી આવું હાઈકોર્ટ જજે તો કંઈ કરવું જ નથી. There is no order of the High Court. ન હોવાથી કેસ એડમિશન લેવલે નકારી મનાઈ હુકમ આપેલ નથી. It was not granted circulation. It is not rejection of Malay hukam. If the urgent circulation is not granted to me, it is not among the અંગે નકર પુરાવો રજૂ થયેલ ન હોવાથી કેસ એડમિશન લેવલે નકારી મને હુકમ આપેલ નથી. This is factually incorrect statement. Then your lordship may go further. Just 10 lines below that. નગીના મસ્જિદ અંગે કોઈ સનદ કે હુકમ મળી આવેલ નથી. Property card is the best evidence of revenue record. મારે આજે land નો record હોય, revenue record. So there are two evidences for any land record. One is the revenue record. It doesn't prove the title. Second is title by way of sale. I am producing a property card of the revenue record. I am producing the 6/8/1923 entries. What else would be required here? PTR, and I'm also producing the PTR, which shows that this is the property of the Nagina Mandir. Then your lordship, go further. મુસ્લિમ તરફથી કોઈ સતત જેવા પુરાવાના અભાવે નિર્ણય લીધેલ છે, નગીના મસ્જિદ દબાણમાં છે અને તેને તોડવામાં આવશે. If it is in 452, it is not in Nabat. And in any event, notice was required. No notice is given. Therefore, my say is that this land may be retained as its status quo.
Because now my learned friend has submitted. Yes, the clinching point is that in property card there is my name, and that is the proof. I don't need to provide any other. But my lord, record provides otherwise also, because in the record I have gone through certain revenue records. It was Sarkari. There is some actual submission which has to be made, which has to be produced on record. Now, fact finding exercise needs to be undertaken. Because solely,
So undertake, no problem. You can file your reply, but till then let it be as it is, because if it is from 1923, when was this built? So let it be as it is.
Even that-
It doesn't make any
also
difference.
it has been mentioned that it was built around before 100 years as per the petition.
And here also this says that, મને હુકમ આપેલ નથી. The matter was sub judice. They had filed the petition. Only circulation was not granted.
As per my time, the question to myself, how would the authority know that a matter is final? It could have been submitted by the concerned representative of the petitioners that matter has been pending, but no stay has been granted. Because how would the authority know? Because there was no any.
Can the authority, without knowledge of injunction not having been granted, say that the injunction is refused and petition is rejected? It is saying that the petition is
It would
rejected.
have been posed by the authority that whatever the petition, whether there is any stay or not. To that query, even a response would have been given. There are certain disputed facts, my lord.
And response, even if given what is recorded, is recorded.
By proposal submission, there are certain disputed facts. It needs to be addressed first before granting any injunction, because that may hamper the development of the entire town. That, my lords, cannot be done at this stage. In my respectful submission, reason being, had it been a case that directly order was passed, they were not heard, or anything, my lords, completely erroneous to the procedure established would have done, even I would have considered that yes, they have to be heard. My lord may also grant status. I would have submitted to that extent. But here they are heard. Documents are produced and they have not been considered. And certain actual aspects of the land needs to be produced even by me and by my concerned the Nagarpalika also. So in my respectful submission, my lords, this is not a case for my lord's exercise of my lord's revocation of my lord's power for granting any interim protection.
No, even this, your development work, you can go on to the other side. No, only this portion.
My
That will
lord,
be,
the
how
development
big
now
is
may
it?
not be increased. That may not be disturbed, even in this area also. That we may continue.
Because when the petition has already been filed, then I think, and they are asking, restoration and
Because the
many
reality
other
is that
things.
this is not even coming in the road line. The whole
That
object
again
is,
will also have to.
no,
be
it is not coming. Factually, I am telling you, it is not coming in the road line. This road is to have a view of the lake. And this view of the lake is being obstructed, therefore this is demolished. And it is in a private property, which it is demolished. And a Sarkari bole છે ને તે તો બધી જ જમીનો સરકારી હોય. That doesn't make it Sarkari.
Another 15 days will not make a difference. You can
Everywhere
file
else
your
they can
reply.
continue to do their work.
In that case, my request for tomorrow. Reason being, I would just need to take instruction only to the aspect of measurement. Even from the concerned Nagarpalika.
No, you file your detailed reply. 15 days will not make much of a difference. We'll post it somewhere immediately on opening, 6th or 7th or 8th.
Because certain aspects, certain disputed facts are there, my lord.
Yes, so
Only
that is why your reply is necessary.
Even
But meanwhile, what will happen is the whole thing will change. Now suddenly everything will be removed the way, the speed at which you're going, everything will be removed and there'll be a road there or something there, then the thing will become infructuous. Yes, so let it be as it is. It is already demolished. We are not saying anything else. Let it be as it is. Status quo be maintained.
Submit only one more aspect. Since the other prayers which are being made, although they are not pressing at this stage, other prayers which include again to reconstruct at the original state.
That is
Even
fine.
if it is granted, that would have been done.
No, no.
Even if the development work which has been undertaken by the.
No, then the same,
can
this
be
thing,
yours.
let it be 15 days. We'll post it on the 7th or 8th of June. Till that time, you file your reply. You can give him an advance copy. You can hear it at that time.
Plan and definitely, because the aspect of my work, the development work being stalled, that
See,
may,
till now, 15 days will not be much
that
of a
can also
problem.
be utilized in other levels, because 15 days will not make a difference. My work may issue notice and make it returnable next week itself, 2015, first or second. Will not make a difference, my work.
Till then, you will keep it on the 8th of June. You file your reply. And till then, you let it be as it is. Let the place be as it is. Their prayer of where is that? E. Till the next date, till you file your reply. Then you can, meanwhile, if you are able to prima facie show that it is in the road or it was in the, there was an illegal, the barn or whatever it was, encroachment or what, then it is.
In that case, may the request this is that the land, original area on which Darga was situated, that part only, because it may not.
Only
happen-
that part.
It may not happen that the other survey numbers are also big.
This was in survey number 452. 452. Only that. 452. The status quo.
Other were the shops of the
452.
ownership of the one. 451 and 453 as per the PTR are the also of property of the one where shops were existing, we are collecting rent from that shops. They have demolished the shops.
Now we will only see this 452. 452 only.
In case of an emergency, some liberty will be granted.
It's always there.
Well, an application for pre-permit, it needs to be. Take my lord, madam.
They can always
Let it
file a
be-
CA.
Let it be at the opening of, you file your detailed reply. I don't see any, so much of this thing. Except for this portion, 452. City survey number 452 to maintain status quo, 452. To file the detailed reply and this. Heard, I don't know his name, but his rules. This you can take this,
I'll produce them.
yes. 8th of June, 8th of June. Well, next.
Say number 5.
You simply check, my lord, you simply check a notice and.
Yes, notice, you have to file the reply and only this much. Status quo ka 452.
Please.
How much you should income tax?
Say number 5, specific number is 7 of 22. The state shall not be served by delay.
Nothing, check.
This is a matter.
So not be served will change.
This is a matter pertaining to the income tax. Issue is like this. That, under the reassessment procedure, as amended by the Finance Act 2021, there was a certain time limit which was prescribed under the Act. That if this is the time, you can reopen only up to a certain time. Before 2021, before the amendment, the outer limit to issue reopening notice was 6 years. After the amendment came into place, the limit stood 3 years up to certain conditions, and it can be extended up to 10 years. This was an amendment. What happened is, even after the amendment coming into place, the revenue issued notices under the old law itself. Based on that, number of writ petitions, not less than 500 writ petitions was filed. Alone in Gujarat, inter alia, other high courts as well, unanimously taking the view that since the revenue has issued notices under the old law, even after the new law coming into place from 1/4/2021, that cannot be sustained. So those notices were quashed. Against that, the department appealed to the Supreme Court. Honorable Supreme Court invoked 142 of the Constitution, and it said that we cannot render the revenue remediless. Based on that, what the Honorable Supreme Court directed is that all those notices which were issued under the old law will be now converted into the new law. This was the direction of the Supreme Court. So even after that, what happened is there is a certain time limit which is prescribed. Now, if your lordships can have the income tax act for a moment,
Income tax act.
I have another
I get your point. The thing is, your assessment here is 1450.
50.
Notice is dated 4/7/2022.
Yes.
Why the urgency now?
What has happened is in multitude of cases, in almost all cases, even when the writ petitions were filed, say after 9 months or 10 months, the honorable division bench, the regular bench, first of all, a view was taken that assessment year 13-14 and 14-15 are time barred. That was a celebrated judgment of this honorable court in the case of Kinara.
Agreed. That all is true. But why this 14/7/2022 do I have to listen to now?
1 minute to
Yes.
answer that query. Based on Kinara Industries, till date, till reopening, till the vacation, the honorable court granted stay
Yes.
regardless of whether the notices were issued 10 months back. That was not even the point of consideration that why did you come late to this honorable court.
No, true.
Yes.
Because at that time you were entitled. Now we are in civil vacation. We have
Yes,
to only
so the
entertain urgent
reason
matter.
would be that they are passing assessment orders by the end of this month.
So let us issue notice in them.
No,
Have they been
notice
issued?
already been issued.
Notices issued.
It has been served.
Anyone is
even advance
appearing.
copy was served to the department.
Mr. Patel, the income tax that he called. There is-
So they know that your matter is pending, right?
We may serve an
It has
advance
been
copy to some of the panelists.
Yes.
Served, advance copy as well as being served on the day.
So they know that it is pending.
Yes.
Yes, so they're not going to do anything
No,
without
no.
filing a reply here.
Yes, I agree to that. But may I just make one humble request? The problem what has happened is, since last time when the matter was afresh, we had requested the honorable court, the vacation bench, to grant at least a stay, because that is what the division bench used to do. The honorable single judge said that no, we will not grant the stay on passing of the assessment order unless and until we hear the other side.
So let us hear that
Now the problem what has happened is an assessment order has been passed.
has been passed.
Yes, because stay was not granted. My only request is till the other side comes up, at least the implementation of the order be stayed. That is my only humble request. Because
Let the
this
other
is the
side-
demand of 9, the addition. has
No,
been-
now once it has already been not passed. That is on 10th of May. Correct? When was the assessment order passed?
Assessment order was passed 2 days back. I have a problem with that. It was passed on 17th of this month. Notice was issued even a week before that. But stay was not. Since stay was not granted, the department says that since you do not have stay, we are not going to stop ourselves from passing the order. And they passed it.
Let it go before the division bench on the opening of the vacation.
Yes.
Anyway, here they have not given you any time. It is not any time is given that within this time you have to pay the penalty.
No,
No, so then let it go before
But
the,
recovery proceedings will start pursuant to this one. This is what.
where is your colleague? The, who appears for the income tax?
So Varun Patel is one of the standing counsels for the income tax panel. There are series of advocates who appear for the income tax panel. He may supply, I think, probably one of the advocates.
I did supply.
They have an interstate bylaws coordination. Somebody would appear.
On the date of issuance of notice itself by this honorable court, I did supply an advance order to the office of Mr. Patel.
I think let it go before the division bench on the opening of the vacation.
I really appreciate the implementation of the order to the state because they have raised such a mammoth demand of almost 4 to 5 crore rupees. He has not earned that.
Where is 4 to 5 crores? See, how much
Addition is
is
9 crores.
9.
So 30% tax with interest and everything, it will come easily to 3 to 4 crore rupees. But he does not have the means or the wherewithal to pay this such a big amount. And it is not that stay has not been.
Had you been granted at that time, it would have been different, but
Yes, but
now it is difficult
But-
because to,
we requested the honorable court to stay. The honorable court declined. Division bench in all matters pertaining to assessment years 13, 14 and 14, 15 used to give a blanket stay.
yes, but the thing is that your notice was dated 10th of July
That was not even the
2022.
consideration. That was not even the consideration whether the notice.
Whether in this vacation urgent matter, can it be considered that?
But
No.
following, I'm on parity. On parity.
So you come at any time in parity.
I would not raise the time of the honorable
Yes.
court.
Let it stand over to 7th of June before the division bench. એના પછીનો બી એવું છે. Same.
But in my case, assessment order has not been passed.
Assessment order has not been passed.
So may I request for a interim relief for this 2 weeks. So that because time bound date is 31st May, my lord. So they will pass an assessment order at any time,
31st of May.
my lord. Because a similar issue is under examination just before the honorable division bench, my lord. And then, my notice is issued for the.
Yes,
assessment-
again, same thing. Yours also was earlier 10th of
Please, my
May.
lord. Please, my lord.
No relief was granted. Where is your colleague? Who is appearing on the opponent side? See if they are around. Let us, have you served a notice to them, copy to them?
Here, my lord, service secretaries are not filed, so I.
Because we have already.
No, but they should at least appear to say something. No? Yeah, somebody should appear, no, here.
Because it is a
Let
matter
them
of-
not file anything.
This is Ramal.
I don't know. Your also notice is 20th of May, 2020. Should I entertain it in the vacation?
Because my lord, the urgency is 31st May is time by, so I.
Where is
we
it?
are under the bona fide impression that they will drop the reassessment. Considering our objections and our replies, but then.
31st of May, where is 31st of May?
31st May. CBDT has issued and circulated only the time limit for completion of assessment is 30.
For completion of assessment. Okay.
Completion of assessment is 31st March 2024, but by way of a board instruction, CBDT has curtailed it down to the 31st May, my lord. May I request my lord to kindly go to the para 2, my lord. May I read, my lord? In
Yes,
this regard, I have been directed to convey that
shall be completed on or before 31st
31st
May.
May, my lord.
Okay. So in your case, assessment has not been.
Not as of now, it is not passed, because it may be passed at any moment. my lord. So my only request is, I may be protected for only 2 weeks, and the matter may kindly be listed on the first week or second week of June. Till then, I may kindly be protected.
Notice has been issued. What is your name?
J.B. Patel, my lord.
For Mr. Jimmy Patel. For the petitioner. Notice has been issued, none has appeared. In view of the submission made by the learned advocate for the petitioner. The the references for completion of assessments have to be completed on or before 31st May 2023. Until date, no reassessment order has been passed. Identical issues have also been dealt. However, the proceedings of assessment will continue with the cooperation of the petitioner and are not stayed. And it is made clear that the assessment proceedings are not stayed. Direct service. Direct service. Huh?
My notes have passed the interim order. I just had a word with Mr. Raval. He was requesting if convenient to my notes, if we can kept tomorrow, they'll appear. If you can keep tomorrow, my notes.
Action week, Hanji.
This is similar, this is for the assessment and 13 my lords.
In this also, you are appearing.
Yes, sir.
So Mr. Jimmy Patel from Mr. Darshan B. Gandhi.
In this case, it required to be brought to the notice of my lord that in this case, the Hon'Ble Gujarat High Court in Kinara Industries has paused the notice for the assessment at 13, 14 and 14, 15 group of
Let
them.
it be final now. Interim.
That judgment is traveled to the Honorable Supreme Court. The Supreme Court has as of now stayed the judgment. But similar petitions is pending before the Honorable Gujarat High Court. So my request is my matter may be kept pending and a stay may
Yes.
be granted.
It is the same like that. In an with same order.
Deeply only. May I request for DS today, my deeply only.
Direct service. Date તો પછી જુલાઈમાં જ રાખી દઈએ કારણ કે હવે વેકેશન પૂછે એટલે 3rd July. Any other matters you know which dates there, so we'll keep it around that
They
time.
are keeping it on 25th of July. Entire group is
So 25th of July.
Say number 8, petition 9139 of 23, Mr. Kausar Isnani, Mr. Raj Toban Putra.
Matter is pertaining to renewal of the passport. The present applicant is at Canada. His passport is was having validity till 9th of March 2023. For the same reason, he moved an application for renewal of the passport in the month of January. The date is 21st January 2022. Yeah. In a moment, your ladyship. Yes.
You come prepared, come on. After vacation, you come prepared.
Ladyship.
This I don't want this. Where is your file? Where is your this thing? You are not prepared at all.
Ladyship, Mr. Jani is out of town for.
So we'll post it after vacation.
Ladyship, only the difficulty is that on 19th of this month, 19th of May, Honorable Court has issued a notice and direct service was permitted. The direct service was received yesterday only.
By
The
whom?
direct service to respond number 3 has already been served. However, the direct service
Let that be.
shorter date may
You
be,
don't know your case.
ladyship, shorter date may be given.
Okay, 6th of June. Let it be after, it's not so urgent. Yes, come on. 6th of June. Come back.
This week, ladyship, if it is possible, his passport has already been expired.
So, does it make a difference?
He is at Canada and he is not having valid passport as his passport is expired in the month of March already.
So it is expired in the month of March. So no problem now. Let June come. Come
For
on,
the same,
I have a lot of this.
ladyship, for the same reason, the renewal application was made several times. The grievances were
So there must be, see, there must be some more
only which is
criminal cases pending against you.
Only one criminal case is pending, wherein the honorable this one.
Okay, March it has already been expired. June, today we are on
Let me
23rd of May. Another 2 weeks
In
will
that
not be.
criminal case, he has already been protected by this honorable court, and the honorable court has passed an order that no coercive statute should be.
You come prepared. Come on. Come prepared. Yes. Yes.
There's one matter where I'm seeking urgent circulation for tomorrow. It is with respect to declaring a person as a willful defaulter. Now, I'm directly covered by a division bench on the issue. I'm not taking the honorable court into the facts and everything. And thereafter, based on the division bench judgment, there is another similar kind of matter where the learned single judge granted me stay in some other case. It's a matter where
On the 25th, the hearing is kept. And once the hearing completes and they declare me a willful default, it has long-lasting repercussions on the businesses, no loans.
No, but they should hear you, no? Let the hearing
but
take place.
My submission in the petition is that they have no jurisdiction to give this notice to me in the facts which are there. Now, that is all that your ladyship will have to look into. What I am submitting is that if we go through the division bench judgment which is there, then the notice is absolutely barred. Because there are certain aspects which have to be taken into consideration before issuance of the notice for hearing. But if that is not done, then in view of the Supreme Court judgment which is there, which says that if the authority is 25th is the hearing, I am requesting for tomorrow. If the Honorable Court will be kind.
Okay.
I am grateful.
Reiterating my request, my lords have seen that how they are doing it overnight. If any adverse order is passed, it may be not be implemented for them.
No.
It will be,
No.
we'll be again have to rush mill order immediately and we may not even get that time.
They will not. Such
Then I
weapons.
rely upon mill order.
Come on, next.
May I have liberty to?
Yes.
Because even calculation for Premura Majas, the urgency is verified. Bank has issued the auction minus. My client has applied to participate in that auction with the 10% amount minus. That amount is more than 25 lakhs minus. And my client is the highest bidder minus. Therefore, the bank has issued H1 certificate in favor of my client minus. Immediately after this process minus, my client came to notice the 4 independent person has given a notice to newspaper that they are claiming the owner of that property and some disputes are pending between them and bank in some court, my lord. Therefore, immediately my client write a mail as well as the application to bank, my lord, but declared bank has not given any proper reply, my lord. Yesterday only bank has given a reply, my lord, and meanwhile, my lord, bank has rescheduled the auction, my lord, on 16th, my lord, without intimating us, my
16th
lord.
of June.
And now, lordship, the second, on second, my lord, the re-auction is scheduled, my lord. Therefore, that is the urgency, my lord. And bank, even otherwise, my lord, forfeited the amount of more than 25 lakhs given by my client, my lord. That is the urgency.
How can they will not forfeit the amount? You
But
can
lordship, they are
participate in the
not-
second option.
They are not intimating us, they are nothing, lordship, they are not even a reply of our.
16th you can come after vacation.
But lordship,
Come during
on the
vacation,
second-
after the vacation.
On the second, my lord, the bank has rescheduled the auction, my lord.
You said
On the same
16.
Property, second, my lord, second of next month, your lordship. 16th, my lord, bank has issued second re-auction notice, my lord, public notice, my lord, and this auction is held on second of this month, next month, my lord.
And they have forfeited your 25
Yes,
lakhs.
your 25 lakhs rupees. Now they are not given any proper reply to my client, my lord. Therefore, tomorrow or day after tomorrow.
Not tomorrow, day after tomorrow, on 30th.
Please, lordship, type copy may dispense with all are legible, my lord. All are.
If they are legible, otherwise no.
Please.
Otherwise I'll straight away stand over to 2 lakh.
There is a petition which has been filed today. So I'm requesting for circulation of
Why?
that petition. The reason being that an ex parte order is passed, removing the petitioner who is a sarpanch on 11/5/2023, which is served on 15/6/2023, 15/5/2023. Removing the petitioner from the post of sarpanch without giving a notice, without opportunity of.
Something must be there, no? He didn't
But
just won't
then,
remove you like that.
As well as the judgments will not say that an opportunity of hearing and a notice is required to be given. Now there
Now
is
he's already removed.
order is passed now within 2 days, the deputy sarpanch who has preferred the application is likely to take charge. No, this is covered by the
No,
judgment.
it's not urgency, it can come over.
Not allowed a similar.
Yes, will not.
Yesterday,
Hmm.
on the count that there is an ordinary remedy available.
Yes,
Yesterday,
So,
council
that
mentioned similar matter.
Only one.
Only one meeting.
That my learned friend is arguing on merits, that I can satisfy that there is this honorable Supreme Court judgment.
no urgency.
No, what will happen that in 2 days without the sarpanch,
He can be reinstated.
when the merit, when the equities are changed, there would be no purpose of filing dispute. And no notice is given, no opportunity of hearing is given.
No
Right.
urgency. No urgency. Come on next.
Circulation for tomorrow, requesting the matter pertains to the Mamladar's verdict. When the deputy collector has passed an order that there is an approach road passing through my agricultural field towards the respondent field. That is absolutely contradictory to the punch road prepared by the Mamladar court. And even affidavit, they have not considered the affidavit prepared under the surrounding landowner, which says that there is no alternate road passing through my agricultural field. Now, my difficulty is that on the 26th, they are going to raise all my standing box and making a road towards my
So where's the collector?
deputy collector.
Where's the collector?
But I'm challenging the order in the Mamladar's court, which is revision under the deputy collector. So there is a remedy available.
No urgency.
Otherwise,
No urgency.
But my difficulty is on the 26th, they're going to demolish my whole standing wall. JCB, they are already prepared for that. It required urgent order, Lordship. At least it feels that they appear before this court and file a reply to that.
No urgency. The petition is filed. No, your petition is admitted.
Petition is filed.
And when was the Mamladar Court Act order? The Mamladar's order, deputy collector's order? Which date?
Not available, and last week.
Then come aware. Come aware. No, I don't.
Only I may be protected only for the week or more than week that they may file a reply and may represent their case. At least that they are not demolish my crop standing off on that.
If it was in April, then what were you doing till now?
And
And you are not prepared also.
I filed several applications before the Mamladar. I represented before the deputy collector. It is that petition is already filed before the Hon'Ble Gujarat High Court. I may be protected. It may be prolonged for some days, but they have not heard and they are going to demolish on that 26.
Do they do that? Do they just one JCB through his field?
Yes.
No.
If it has been filed.
Yes, that is what. That time only it would have been this thing agitated. Yes, next.
I'm requesting for circulation of the facts of the case are despite that I am a guarantor of a private limited company. Private limited company await the loan from the bank. Defaulted, they were declared NPA, my lordship. Now, my lordship, as a guarantor, my lordship, I have filed a section 94 application before NCLT Ahmedabad for initiating informative process. That matter was listed on 19th of April. Notice was issued. It is posted on 6th of June. Now, my lordship, as per section 96 of IBC, the moment a guarantor files a section 94 application, interim moratorium comments and no other legal proceedings can be carried out. My lordship, still during the pendency of this application.
Tell this before that on June.
No, my lordship, my submission is that the learned executive Mamladar, my lordship, issued a notice to us that they will be taking physical possession of our property tomorrow. That notice was issued on 14th of May, man.
Tell the Mamladar that they cannot.
No, my
do
lordship,
that.
we have issued a letter to the Mamladar.
Yes.
My lordship, they are not accepting this. They say that we don't believe this provision of 96, my lordship. My lordship, we have already issued a letter on 19th of May. My lordship, but
Let the Mamladar not believe this thing. Then
my lordship,
you
but
can-
they are going to take physical possession. If my lordship, tomorrow if they take my possession of my property, my section 94 will come in practice, my lordship. I have issued a letter to the Mamladar.
Your section 94 is not final as yet. You have just
No, my
filed
lordship,
the
that's the
application.
provision that till the admission of section 94, interim moratorium commence, my lordship. Section 96 says that interim moratorium commence from the date of filing of application and it remains till the admission of that petition. So the moment the NCLT admit my petition, my lordship,
Besides this, no alternative remedy.
no, my lordship, alternative remedy for that aspect that my lordship, the NCLT, I have already filed the petition.
That
my
is
lordship.
one aspect. What
My-
about the Mamladar notice?
My lordship, we have already filed a securitization application. my
Yes, so you have to go
lordship. My
there.
lordship, but today, my
Not
lordship,
in
given
this
that
vacation.
DRT is not available, my lordship. And they,
Yes, so because this court
my lordship, and NCLT is also observing, and my lordship, this is a provision.
not
of
urgent,
my lordship.
not here. Yes,
But I am requesting for a circulation of a tender matter on 25th on Thursday. The urgency is this way that the bids are closing on Friday on 26th of this month. And they have incorporated a clause which is so ambiguous that it can disqualify. They have not clarified the clause and
no.
lordships have granted circulation of a similar tender matter on the very same date for the very same tender.
PGVCL.
Lordships.
But that they said that the portal was not working.
But
It was that the portal was not working and they could not put in their, it's only an online tender and they could not feed in their online tender. That was the, no, We are not here now to decide about the ambiguous provisions and
Well,
all that. That you decide
Well,
however you
The
want to.
urgency is this, right, Manoj? The 26th bid is closing. If I put in a bid today, Manoj, and that provision comes into play, Manoj, I'll be disqualified, Manoj, to or any further bids in GUVNL. Manoj, for that I need, Manoj.
No,
Well,
not urgent.
Manoj,
Then it is your choice, no?
Manoj, if I don't know, Manoj, if I'll be disqualified, I won't.
Then with that apprehension, you cannot come here.
Because
Not
Manoj,
no.
we have also asked for a pre-bid clarification. But for that, Manoj,
Go there and ask them.
well, I have asked them, they have not.
Okay.
But they are not.
The thing that I have permitted is specifically it was stated here at bar that the online portal, the tender has to be filled only online,
It is only.
and the online portal is not working.
But that is.
That was the
Those are not my instructions, Manoj. Those are not.
no,
my-
that is what I have permitted. Nothing besides
Those are
that. I will
not-
not listen to anything besides
The
that.
claim there was that because the portal system technical glitch and these are
Yes.
going to file his
Yes.
participation.
Yes,
Here is the case, my lord, wherein the provision.
ambiguity.
My lord, the purview of the company.
Well, if I may be permitted, but on 26th, that is the last day of the bidding. My lords, now the provision says, my lords, lists out 10 eventualities where if I don't fulfill that, I will be disqualified and blacklisted. That means, my lords, if for the next 3 or 4 tenders, my lords, I have asked them for a pre-bid meeting, my lords. For that, it may be listed, my lords, I'll not.
No,
But
no,
they are not clarifying because
No.
I am not aware whether as to I will.
no, that was on a different footing. You are making a little different submission,
But I am not.
which is not proper.
But I am making a submission on my own independent footing that if on 26, my lords, I prefer a bid and I do not have a clarity on clause even after repeated communications, my lords, I have put the communications in the petitions also. 4 communications I have put where I.
So you are sufficiently protected. You are already taken your, you
But
have already
it-
taken your, what you call, you have already told them that
But they are not clarifying. They are saying no clarification.
fine,
But
it's not urgent after vacation.
But
Yes.
I will not be able to prefer the bid logic. That's the problem. Man. But only.
No, that is your apprehension.
But-
No, that,
The guise of such litigation.
Yes.
Anything that I should be
But-
qualified in some way.
yes, no,
In any way or the other.
it's not urgent. Come on, next.
Request for circulation for pre-detention, Assam Metro. The
Pre,
pre-detention,
how pre?
Lord,
Who told you? Show me your notice where the police has said that you are being put under PASA.
in my matter, my lord, the co-accused has been already detained under.
Co-accused, it's a different
In
thing.
my matter, notice is not issued, but 2 police constable has called my client notice, both named are there in petition notice.
That he will be arrested under PASA.
They have made statement before my client notice, if we will detain you in PASA, and if we will not detain in PASA, there is externment against you. So my client came to refer this honorable court. Specific notice one Lalit Bay Police Head Constable of Kodina Police Station, and another is Jagdish Bay.
That is a-
Affidavit?
Specific notice, it is also mentioned in my petition notice. They called my client their notice and made the statement notice.
But still they didn't arrest him.
Yesterday itself, therefore today.
No, they have taken him in PASA.
No, yesterday they
If
called
they
my
are
client.
calling him to
Notice
tell him,
Yesterday itself notice, they called my client, and even otherwise notice 2 offenses are there. My name only given by the co-accused notice.
that is on merits. I'm
No,
not listening
is
to that.
the process I'm saying.
I am saying that if they have called you and
Yeah.
there is a PASA order against you,
Yeah.
then why didn't they serve you?
But notice they specifically stated him, "Okay, we will arrest you in PASA."
If there was, they would have arrested
But
him.
notice they specifically instruction is there.
How is it possible? Bola with
Otherwise.
come. And then he's saying
No,
that
no.
there is a PASA order against him.
Because
But he's not arresting.
other 3 persons are arrested.
Yes. No, no.
Otherwise I will not made notice. Many petitions we are filing and only.
So fine, I have absolutely no, after vacation you can
But
file.
notice he will.
No
arrest
urgency.
him.
Even that there is no
Another
notice.
day,
No.
They arrested 151 of GPF.
So just with an apprehension, how
They
can you
taken the
come?
custody for 24 hours.
After-
And then after they serve the
Yeah,
order.
This is the
There is no
problem.
remedy. Before detention, my lord, there is no remedy, there is no notice.
So
there is
merely
nothing
on
for the
apprehension, you cannot come here. That They may do it.
But only for the sake of moment.
Of the honorable court before the commencing of vacation, has put exemplary costs on such petitioners to
Yeah.
come before this court without any apprehension, just on the guise. And my lord.
That is what, and should it be
Some
entertained during
guidelines
vacation?
also, lordships used to earlier,
Yes, but-
before the vacation, lordships, but they are not, lordships, follow the guidelines by these honorable court. Because in these, one FI lordships, one lady was arrested, beaten by the police and stated, give this person's name, lordships. I was not there, lordships, my role is not there, lordships. No muddamal is recorded from me, lordships. I have tried for suicide, lordships, attempt to suicide, because they are harassing me, lordships. Therefore, he can, at least my lord may only, they make statement before my lord, okay, they will not file any pasa against my client, lordships.
That cannot
Because
be.
lordships, client will suffer. This is.
We don't know what is
Yes,
the allegations against you. We don't know how many cases are there against you. We don't know your
I
history.
have filed the two FI.
Even how can they make a statement like that?
But lordships, they call the report, earlier, the bench already, whenever lordships.
Court is now not entertaining such petitions. My lord.
But
Yes,
lordships, court
No.
also.
Come on.
Right on.
Yes.
Lordships, court also.
No, come on.
On 18th of May, notice has been issued for removal. The period ends on 24th tomorrow. And in the very innocuous notice, after a period of 10 years,
What notice?
they say that you file
Demand,
reply
encroachment.
about removal of my everything, and the land is to be handed over back to the original owner under the town
Who
plan.
has given a
The
notice?
corporation has given the notice.
Corporation has
Yes,
given notice
Surat
that you,
Municipal Corporation has given the notice.
that you give the property back to the original owner?
Yes, there is no encroachment. It's a private land. After a period of 10 years, somehow notice is issued under 6833 of Town Planning Act. And they say, તમે reply file કરો, સાંભળવાની જરૂર નથી, તમે appropriate decision લઈ લેજો. On
Have you
18th
filed the
it is issued.
reply?
Sorry.
File the reply.
Reply is filed, but they said that we are not going to hear you. Reply આવશે, જો અંદર જ લખ્યું છે નોટિસમાં, reply આવશે, અમે જોઈને appropriate decision લઈ લઈશું.
Okay, then
No
you can
hearing.
challenge the decision.
No, the problem is that they are there for the last 40 years. Taxes are paid. I have annexed the bills to show to the honorable court that they are there. The right is recognized. Now on 24th tomorrow, because it is filed today, they were in the process of filing reply. It is done. And because of Saturday, Sunday will not be, on Sunday the offices were closed. Therefore on Monday they have filed the reply. And immediately I have moved the petition. Tomorrow there will be a demolition. There are 30 members.
But you said that they have asked you to hand it back to the owner.
No, they said that you remove everything. There are stables, there are cattle. More than 60 cattle are there. There are 7 families residing there for the last 40 years. And now under the scheme of town planning, everything is done in 2013. Now they say in 23 that in exchange we have to give this plot back to someone else. X to Y, Y to X. And you are on X property, therefore you go out of the property. Taxes are paid regularly. Electricity bills are paid regularly. There is no encroachment.
They have given you a notice. Now you have to go before them, let them
They have
hear
said in the
you,
notice, no hearing. You only make a reply. They'll say
make a
that is-
reply, make a
that is done.
reply.
That is then the problem is that the entire family will go, all 30 members of the family.
No, you make a reply.
That is done on 20th. It is received. I
Yes,
have
then
taken
let them
Let me-
decide.
I am very worried that their action would be taken because.
No, they have to decide before
But
action.
they
How
said
can
that
they?
no hearing. Due process of law will not be followed. In the notice itself only they have mentioned. I may show the notice. The
Is it
hearing now
possible?
the judgment.
Yesterday, honorable Apex Court, while confirming the orders passed by the single judge and division bench passed by Delhi High Court, has clearly stated that whenever issues such as a person who is residing at any particular place for around
Long time.
long time, that has to be adjudicated by appropriate suit by proper suit.
Yes.
Petition file, sir, petition file ના કરે પણ નોટિસમાં એવું લખ્યું છે no hearing. I may just show the notice and if reply
Which would be the appropriate forum?
no, this is the appropriate.
No.
Because there won't be any
No.
alternative, any other application remedy. Or petitions are being entered. I have filed many
Yes,
petitions
in
here.
not in the vacation.
They will be removed. There is a specific date.
No, there is, you have an alternative remedy.
But I have.
And as yet, they have not decided, let them given opportunity to let the authority
This was-
decide.
This was lordship my petition. Reply is there. In the notice they said that you file reply. અમે નક્કી કરી નાખ્યું સુનાવણીની જરૂર નથી. If
તો
they
નક્કી કરશે કે તમે ત્યાં જ રહેશો.
7 દિવસનો ટાઈમ આપ્યો છે તોડવાનો કે 7 દિવસની અંદર તમે નહીં તોડો તો અમે અહીં તોડી નાખીશું.
This is not the appropriate.
That
You
is
have an
what is
alternative
mentioned in
remedy.
the notice. The notice is very innocuous. Therefore, I have moved immediately this honorable court. Reply is done.
Not in
Not
vacation.
Only a minute more. On 20th, reply is fine. For these 3 days, they have not called me. Otherwise, also, if they wish to call me, all those families, for the head of the family, they have not done. There are cattle.
Let them decide. Come on, next.
Problem would drop up soon because
No.
the entire family would
Not
be
in
doing.
vacation.
There are stables, there are, cattle rearing, work. is
Not
going on.
in vacation. You have alternative remedy. Yes.
Order 43, a bit from order was preferred before the district court
Hmm.
for an order passed under 39(2)(a). Because I am behind the bar civil
Civil
prison.
prison.
May I request for tomorrow or day after? Because,
You are already in civil prison.
yes, I am. And by the time 30 days have been imposed upon me, I am taken into custody. Plus, without complying the procedure which is laid down.
You can go before the same court. No?
Plus, in fact, I have chose a district court as in appeal. I have preferred because it was 39(2)(a), the remedy available under the CPC. The remedy available is under 43 because I have preferred it because now that is rejected.
It would be in an execution petition, no? Order 21.
No, not 20.
You are in civil prison
I am in
because you
civil
did
prison.
not comply with
39.
what?
39(2)(a) breach. There was a breach of order.
Okay.
Therefore, I prefer that leave. Now, since I have no remedy, because maybe on
The
Thursday
remedy
or
is-
Friday, by the
to
time
you-
I will just complete the sentence, because this will turn infructuous.
But then you have breached, you have committed a contempt.
Because that is without following this honorable court in appeal from order has decided there is a judgment of the honorable apex court. Because judgments of Prashant Bhushan, we have our own case of Mr. Yatin Oja also. There has to be a procedure. When the law provides for 3 months of sentence, why did the learned trial court impose only 1 month without hearing, without framing of charge, without allowing me to lead the evidence? Completely contrary. Because if in contempt proceedings, if it is asserted only on the basis of the pleadings, then this is nothing but a summary.
You mean to say you would not have been given a notice? You would not be knowing?
No.
You were completely unaware about anything?
In fact, the reply was filed, but
Ah,
but
still willfully some actions have been done.
no,
You get the papers and come tomorrow. Let
Very
me see. There. Yes, next.
Lordship, in one of the members, I was protected since 2006 in a special civil application filed in the year of 2006 with other 441 members. Now in the year of 2023, on 26 January 2023, the purposefully started the activity of demolition. So I have filed a contempt proceedings before this Honorable High Court, which was dismissed for default before vacation. Due to it was fixed for the instruction from the client, but as he was suffering from heart ailment, he was not able to attend the court, and the same was dismissed for default. So for the urgent situation, I was pressing this matter for the situation. I am
Restoration, no.
particularly
No.
I am protected since 2006.
Yes, but
And till the
then,
day.
see, you were not, this thing alert. And now it's dismissed, but now you want restoration?
I have placed
In,
on record.
no,
I have to place the record. He is suffering from
vacation,
heart
after vacation.
But till then the demolition.
See, this is not for, somebody who is sleeping over his rights. He had heart ailment.
Yes.
What was the advocate doing? What were
Lordship,
the others doing?
Lordship,
There were
shortly-
400 and how many
I apologize
people
for the same conduct.
after vacation? It's not urgent.
But till then the activity will be completed and the
No,
part will be demolished.
you
The part
were
of the-
protected, you did not take the chance. Come on.
But Lordship, the matter is of a serious nature. He was due to the heart ailment suffering, he was not able to attend the court, and the same was dismissed for default. As the matter
Now
was-
you come in vacation.
but
for
Lordship,
restoration.
till then if I am not pressing that, till then the demolition activity will be completed.
When was it dismissed for default?
Before vacation, before 1 week of vacation, Lordship. And that immediately I filed, but it was for the objection. Now the objection also been cleared before this honorable court. So I am pressing this application because he was suffering from attainment. There is a limit in ground, Lordship. So I am pressing this application. If I am not pressing,
Tell me the date on which it was dismissed for default.
Lordship, before 1 week of the vacation, it was
Okay. Okay.
Lordship, another matter I am pressing for the urgent situation is a fraud decree was obtained from the honorable court by suppressing materials before the honorable court, which had come to the note to the applicant. He made an application to recall a degree with an application to stay the properties because he had a knowledge that the properties have been transferred to the third parties. The stay application was dismissed by the civil court. Then it was under order 43-104 section. It was appealed to the district court. The district court has also vacated the stay. Even surprise to this honorable court, no any application from the either party has been made to vacate the stay. And at the present, it has been made to vacate the property on the basis of fraud decrement. So your lordship, I am pressing for the SC of further separation because the stay of
Execution petitions are filed.
no execution petition is not filed.
Then
In the year of 2011,
what is filed?
an application to recover a decree,
What application?
decree obtained by fraud before the honorable court or lower court. And particularly a stay application was moved before the honorable lower court. That was dismissed. That's what telling before the district court. It was again dismissed, and the stay is being vacated even without following the rules of order 39. No any application has been put from the either party that I want to vacate the stay.
It is not like that. Nobody will do like that.
But
It has to-
particularly after coming to know that they are transferring the properties, I have given legal notice to also them.
Yes,
But
yes.
then also
Now,
they
then you can approach the civil court, no?
I have approached the civil court.
Yes, so that
they have
is your
decided the matter. We have decided the matter. Even I have made an application that the order passed by the district court should be stayed because as the vacation is going on, I may not be able to challenge the order to the Honorable High Court. So particularly that application was also dismissed. Particularly,
So there must be, this is not urgent.
but
You have alternative.
but
Come on, next.
Lordship, one minute can be given. In the district court, particularly the application has been finally disposed of. Finally, it has been disposed of. And
So your appeal is filed.
yes, sir.
Yes. So let it be. Let it come in seriatim.
But your Honorable Court, the decree has been obtained by making of separation before the Honorable Court. The decree is obtained by fraud and misrepresentation.
Which was again dismissed by the district court.
The stay application has been dismissed, not the final application, Your Honorable Court. The stay application has been dismissed.
So against that you have filed here.
Yes, against
Come in seriatim.
but particularly.
The matter is still sub judice before the district court.
But the stay application has been finally disposed of, Your Lordship. In
On
the district
merit.
court- Yes, on merit.
Yes.
And particularly, I have filed an application that I may be permitted, this order may be stayed till the vacation only, till the 6th June, so that I can apply before the Honorable High Court.
Which was rejected.
Yes, which was rejected.
So now you have filed the appeal.
Yes, I have
Let
filed-
it come in seriatim, not urgency.
Yes, Lord.
Yes.
Consideration of income tax matter for the day after tomorrow pertain to reassessment.
Yes.
I'm legal tenant school lot. Yesterday I mentioned and
Yes.
there is a legal rent agreement is there.
Rent agreement, I don't want to see. The school is sealed.
Yes, Lord.
Yes, because the dues are not paid.
Borrower has not paid this amount of the due by to
Then how you are running the school?
with sanction from the both
Who is the borrower?
borrower are the different lot.
Who is the borrower? The landlord. Yes. And you were paying the rent to the landlord. Yes. Then you had to ensure that this thing. Now you tell the bank that whatever is due, you pay.
In petition I have brought notice, but they have elected me without giving me notice. And
Who has evicted you?
bank
School or the bank? The bank or the landlord?
and seal the property. Now the vacation is going to finish and the school will.
Yes,
And
Monday, 29th. Salmagan Monday. Yes, who is a new person here? Please don't come second night.
But not for review, but for seeking fresh circulation plus post
Another.
execution. Yes, yes. Post execution passa. So the
Post execution, yes, yes, yes.
I'm sitting, sir. The authority has passed the order for reducing of salary 18,000 to 12,000 without any due process of law, without even notice, and even that order was not provided.
Recovery can be made after vacation.
But the entire employees, it affects the entire employees. There total 300 to 400 employees that affecting.
After vacation.
Lordship, may I mention? Lordship, same BCL matter for tender. Lordship, the only request is, I know I shouldn't have come in the vacation bench, but the urgency, the entire communication has been during the vacation, and the last date of tender is also during the vacation.
Lordship, and there are many aggrieved entities, like 100 to 150 entities who are aggrieved by
Your
this
Lordship,
condition.
as my learned friend said, these litigation, Lordship, if the tender is finalized, when it comes on the regular board, even then more litigation will continue. Pursue to that.
No, but
And we have very
what is
limited
your
request.
relief? Let me understand this.
Malos, if the relief is either they give us Malos a pre-bid query, or Malos they remove that clause, or Malos at least someone,
No,
or at least Malos someone from their side comes and says that till the pendency of that petition, I will not be blacklisted. Well, there are 150 to 200 entities which will be affected They are specifically in the business of, this is a tender for transformation, a transformer reparation. Because these 150 to 200 entities all are specifically into the business of repairing transformers.
What is your thing is about the ambiguous?
Same thing. Lordship and Lordship, the only prayer is if they are not replying, if they are not doing, what efficacious remedy do I have? There's nothing other than approaching this honorable court, and it is directly affecting a fundamental right under 19.
We have instructions, my lord, that the petition that Lordship, well, I have not seen the petition, but we have instructions that the petition that Lordship are permitted to be circulated on 25th also challenges that condition. That ambiguous condition is
It
also.
was a specific
But that is not my
request
instruction, therefore I cannot.
that the online tender, the portal is not, you cannot, portal is not working.
That is not, that
Yes.
is not my. But my lord,
So that is the only request that I am
my
going to.
only anxiety is.
Because if 25th is the last day or 26th is
26th.
the last day, then that portal should be open till the last day.
Lordship.
Now you cannot close it earlier.
Lordship.
That is what.
But
Otherwise, the terms and the conditions and all that.
I am
would
aware,
be-
my lord, that could have rated, my lord, the only anxiety is, Lordship, if I fill the tender. Now I have asked them 100 times that please clarify whether I will be, whether this will cover this or not. They have not given me a meeting also. Now, in absence of such clarity, I fill the tender. I am ready to fill the tender also, Lordship. I am ready to fill the bid. But in that case, my lord, if they interpret it in such a way that I get blacklisted, my only job is to, my lord, repair transformers. If this is the tender that I bank upon every year or, my lord, every 2 years. Am I?
No, I think, in this way, it is being tried to influence them that we have filed petitions, so.
Lordship, request is based upon anything. Let there be a cause of action.
Yes.
That my learned friend is not aware about that, he may not manage.
What you want to stay the tender?
No, if.
How can it be?
If your lordships are convinced, they may give me a pre-bid meeting saying that we will clarify. That
And
will
not close the tender portal till the date. You give us a meeting, you give us a clarification and just not close the
Or give
tender.
us a lordship
Portal.
extension.
Lordship, if they close the tender portal, we have no efficacious remedy. We have been asking them for the last month.
I have produced communications, lordship. It is not as if I have rushed to this honorable court saying that no.
So you have done.
I have asked for a
So it is all on record.
Lordship.
Yes. Now, in case they and why will they blacklist
Because the
150
clause says so,
people?
my lord. The clause says that if you violate any of these conditions, we will blacklist you, my lord. If I get blacklisted, the only job I have today is transformer repairing. If they blacklist me, my whole entity goes.
They have not yet.
But they have not also clarified lordships.
They have not.
I'm not
See.
saying, I'm at no point saying lordships, if at that moment of time, on 25th, if lordships are convinced to stay or not to stay, my lord, that is.
No,
I'm
stay
saying
and all that.
I'm only alleging lordship that if my petition is,
The only prayer was that the portal was not working.
but that is not my instruction, so I
And
cannot say
if
that.
the portal is not working till the time that the tender says that you can fill up your online tender till 25th, let's say till 20, it should be open.
Lordship.
That is the only thing that would be considered, nothing else.
That's the only.
The terms and conditions, whatever are of the party who is flouting the tender. I mean, if it appeals to me, I go. If it doesn't appeal to me, I don't go.
But on my only request is, my lord.
Now, how can you force and,
But I'm not
say
forcing.
that you say these are the terms and
No,
conditions?
I'm not saying. My lord may please, my lord, therefore the petition only, my lord, on that day, if my lord say that my lordships are not inclined, I will not argue further. The problem is, my lord, I need to show the record to show that I have bona fidely not pressed them. My lord, I have requested them that, sir, give me a pre-bid meeting. I want to discuss this clause. I am not saying you change or you do this. Or
Normally tenders don't have pre-bid meeting or they have.
they usually do lordship. This one does
I
not
have
have
a question to myself, my lords. Can this honorable court at 26?
Yes.
Is it? Well, that will be on basis of the matter. That will be on the basis of.
Here is a case, my lord, where they are trying to dictate as to
Yes.
how politics should be. It cannot be like
That is,
that.
that will be the merits of the matter. I'm right now,
No,
my lord,
you cannot do that because
my humble and respectful, my lords, I'm not saying my lords, there are 150 to 200 people,
I don't want
entities.
them all to come.
entities, my lords, who are affected by this condition, and this is a genuine, my lords, if I am on that day, if I'm not able to convince my lordship on that day that I have a genuine difficulty, lordships may not protect me, my lords, but my lords, not circulating the petition, my lords, would affect me very adversely, my lords.
I would not be able to fill the bid in. If I fill and I am disqualified, my lord, I'll have a
See,
long,
you
long
have
battle
two
to fight.
players. You come up with two issues.
Yes.
One is the ambiguity,
And
and
unreasonable.
one and the
Second is
the,
unreasonable.
second is the pre-bid meeting,
Lordship,
which again cannot be done.
my lord, if,
It cannot be done.
but if they can, my lord, there are,
Ambiguity, if it is ambiguous and something has happened, you can
it
always.
is also
you always
unreasonable.
have-
I'll be able to solve it is also unreasonable. My lord, they have just put words without any definition, which would, given, if given wide interpretation, my lord, most of the entities would disqualify from this. Most of the entities. I was, and my, all the communications lordships,
Anyway, this one is coming up. Let us see. You
Madam,
are saying
I-
your same matter is.
I may be
is-
permitted to search my.
No, I don't.
I'll not pester the court on that day, my
No.
lordship, I'll only take 10
You
minutes.
can be present here.
But I'll
otherwise,
only take 10 minutes of the honor.
no, come on. You also have told
Lordship,
no. You also.
Permission to start doing school, one English medium, one Gujarati medium, there.
Again, you come.
Please, Lord. I'll come with the order, my lord. There's basically-
Yes, I told you to come with an order. Yes.
Lordship,
Yes,
there's
yes.
no efficacious remedy available to me in the same matter. And
But
nothing.
what you are seeking cannot be done.
Lordship,
I'll pay that thing, my lord. It seems-
I'm not seeking, I'm very limited prayer to the said petition, Lordship.
Okay, since I have already allowed those,
No.
you both will be permitted since it's the same group.
Lordship.
But please don't ask for any mandamus kind of a relief that, have a pre-bid meeting and all. It will
But we are
entirely
not,
depend on that.
we have asked for a mandamus, regarding a clause for a.
આ બંનેને
meeting date.
yes કહી દો. પેલી મેટર છે ને એટલે એની જોડે જોડે સામે.
Highly obliged, obliged, your lordship.
What is this page 15?
તારણ, my lord.
Huh?
તારણ.
તારણ. અંગ્રેજી માધ્યમ નવી શાળા માંગણી કરેલ છે નોંધાયેલ છે શાળા મંડળની દાખલાની નકલ.
First they said that is a all criteria would be met. And they said due to the permission given to Gujarati medium, it cannot be done.
પૂરતા ક્ષેત્રફળ વાળા પર્યાપ્ત વર્ગખંડો ઉપલબ્ધ નથી. Where will you run the school?
Fifth line from bottom line.
Yes, એમાં you want to have it in.
I mean, fifth line from bottom line. પૂરતા ક્ષેત્રફળ પર્યાપ્ત 5 વર્ગોની સુવિધા છે.
Yes,
They
શાળા મંડળને ચાલુ વર્ષે અપીલ સુનાવણીમાં ગુજરાતી માધ્યમની એક થી પાંચ વિનાનુદાનિત ખાનગી પ્રાથમિક શાળા શરૂ કરવાથી મંજૂરી મળેલ હોય. રજૂ કરેલ નકશા પ્લાનને ધ્યાને લેતા. So for the Gujarati school, it's okay. It does not. Yesterday you came up with a different submission saying that they told you you run the
I
English
was-
medium school in the morning, the
I
Gujarati.
have already answered with see the page 20, my lord. I have given undertaking, my lord.
No, undertaking, no. Undertaking
It's the
you
same
can give.
undertaking. I will run English medium in another shift and Gujarati medium in another shift, my lord. And upon their advice, I have put the case.
They say
Because
that
I am-
for one school it is okay, but
Because
they,
I am using the same premises for the both the school, my lord. I will using both same premises for the both school, my lord. So if criteria are fulfilled for Gujarati medium, then why it is not for English medium?
and this is DPO. प्राथमिक शिक्षण नियामक.
For the same premises, they have given permission for Gujarati medium. And for same premises, they are saying that criteria are not fulfilled. And therefore, I have given undertaking.
But that was not your this thing. You wanted to run both together.
But I said,
And that is why they said that for the English medium, for the one medium, Gujarati medium is allowed.
please watch it. Put the same premises. And I will be using same premises for English medium, but in different shift. And to the fact, I have also filed undertaking, madam. On page 20.
You were giving undertaking, but what you told yesterday, what did you say? that they said,
Upon their advice, I have filed this undertaking, madam.
where is the advice?
Because of 13th,
Where is it?
it is not there, madam. But I have from June, the next academic year.
What is the strength of your students? How many students you have?
It is new soon, madam.
Then,
Recording for you.
yes, you don't have any kids. So now run the Gujarati medium. Next year, again you can apply.
Is not.
Lordship, may I request on behalf of
Although it will be, my name is given the 29th, but my grant says that on 25th, there is a result of Gujarat Board SSC. SSC Gujarat Board, and they have to give LC to the every.
Okay, okay. So,
Possible.
25th is the result. So tomorrow. We will hear it tomorrow because in case they need to open the school to give
may
the.
I revive my request?
And my,
Uh,
my filing number is not.
Without filing number.
Without filing number, how can it be? આજે ને આજે તો નહીં થાય કે?
Because everything is ready, only thing is,
આપણે file તો કરો. File તો
Go see, if it is, then it will be, otherwise it will be the afternoon. Because you said the results are on 25th and you need to give the LC.
So the movement lordships declined that circulation, but I have instructed them that whatever lordships have directed about alternative. Today morning at 10:30, the officer has come, has said that you remove your belonging and the kettles. This is the grave problem and this is the notice lordships were kind
Why is this?
Sir, હું ત્યાં જવા જ માંગુ છું કે મને સાંભળે this could be disposed of the moment the corporation advocate could make a statement. નહીં તો હું ક્યાંયનો નહીં પિટિશન બી જશે ને મારી આવો બી ધારો કે
Supply in advance copy to the
Okay.
corporation.
Because they have refused.
Will have to issue notice.
They have refused. I have informed the concerned advocate that this is the problem I am facing and I will be requesting for.
How many days you are given?
But on 18th notice is issued and on 24th, tomorrow is the last day they have mentioned. This, the wordings are, જો તમે મુદતની અંદર વાંધાઓ રજૂ કરશો તો તે અંગે વિચારણા કરી યોગ્ય નિર્ણય લેવામાં આવશે અને તેની ખબર તમને આપવામાં આવશે. And today,
ખબર તો આપવાનું.
પણ સાહેબ, today they came and said કે આ તમારા kettles છે લઈ લો, વર્ષોથી છે, stables તમારા remove કરો and all your belongings you move out with your family. Orally, I said that give me the name at least.
Is your petition filed at
Yes, it is
time?
filed numbered in the morning.
In the morning?
Yes, because
We'll
immediately,
keep it day after tomorrow.
but only one request, I have annexed tax bills to show the names of the persons. Those type copies may be because it is very urgent in nature. Therefore,
25th or 26th week.
25th,
Supply in
day ends
advance
on,
copy to the corporation.
Yes,
day ends on 25th.
you
Only therefore.
supply advance
I
copy.
do that today by the evening, lordships may give me 20, not 26. That jatu રહેશે નહીં.
Okay, 25th.
And those
આજે
type
23rd.
copies of bills may be dispensed with. All are legible. I just wanted to.
If
show
it
that-
is legible,
Only
if
names are
it
to
is
be
not
shown.
legible,
Sir, XYZ neighbor बताना था कि they are paying. bill.
વાંચીએ એવા હોવા
હા, છે,
જોઈએ.
છે. She's not trust.
વંચાય એવા.
સાહેબ, આપને મારી ઓછી હાલ 1 મિનિટ માટે
ના,
બતાવો.
નથી મારે.
Lordship, may I make similar kind of request on behalf of Mr. Chinmay Gandhi?
You come prepared, I told you.
This is other request, Lordship.
You were coming with your mobile like that.
Lordship, the similar kind of I will request for you.
Request tomorrow. Come prepared.
For serial number 8,
Come prepared.
for serial number 8, may I request for next week, ma'am?
Today?
Yes, the serial number 8, my passport, may I request for next
See,
week?
passport is not urgent.
Lordship,
It is already
the
expired.
difficulty is, the passport is already been expired in the month
In
of
March.
However,
Full March.
however, the application was made in the month of January for
Yes.
renewal of the
So
passport.
full March,
The
full April.
authority has denied for renewal in the month of March. The date is 25th of March. Then after the petitioner has raised his grievance before the authority, the grievance was closed on the 24th of April. The 24th of April, the grievance was closed from the side of the respondent. On the 5th of May, I have.
They refused to,
Yes,
that was it.
they are demanding.
Or they told
They
you
are
that
demanding
there is a
specific
criminal
order.
case pending against you. That is why get a no objection from the concerned court,
Please, your ladyship.
which is the procedure.
However,
Did you approach the concerned court?
that is what I am trying to explain the honorable court. That in that matter, I had applied for 482 for the postment of the FIR, And in that matter, I had already been protected by the coordinate bench by way of not filing of the charge sheet and not to take coercive step against the present petition. So there is no charge sheet against the present petition.
No charge sheet.
No charge sheet is there.
No charge sheet, huh?
Yes.
And remember what?
Lordship, the order is there. Annexure B is the order of
Okay, 26th.
I am grateful.
If it is no charge sheet, huh? Otherwise you have to
Please,
go
please,
before the
I
concerned court.
am making statement. The order of that washing matter is there. Annexure B.
Okay. And that is still pending?
Yes, it is pending for final hearing.
Which year?
2020 matters.
Okay. Okay.
Because I failed to file the service affidavits because somebody from the office of the union.
Passport, yes.
The passport office
Yes.
will have to appear.
The difficulty was that on 19th the direct service was permitted. However, I received the copy of that direct service yesterday only. I had served the
So
copy
we'll
of
keep it on Monday, that is.
uh,
Monday.
File an affidavit.
and the Ministry of External Affairs is at Delhi, and the copies for there has already been sent yesterday only.
So we'll keep it on Monday.
So
So
they
till
will
Monday it will be clear.
Please, Your Honor.
Yes.
And
May I serve the advance copy to my learned friend because otherwise private bar appears generally from the panel. Whatever he
Corporation,
says.
I'll not appear.
Yes.
Ah,
it's a corporation.
Corporation, no.
And I-
Corporation,
approaching
whichever is the,
Yes.
Please, one last request, Your Ladyship. The similar kind of matter is there, the group of matter. There are
you come
37
prepared.
The weather turned absolutely bad. Unbelievable. What I saw the day previous to when I saw while I landed to what I was now seeing, sudden change. It turned blizzardous. How this particular thing came up was because Kal Bulkuma realized that the map that he was being shown had a straight line drawn from a point called NJ 9842 joining the Karakoram Pass. It's not one man who does it. It's a team that does it. General Chibba was quite forthright. He said, look, the Chinese have occupied Aksai Chin because we were not at Aksai Chin then. And since it's our area, we must occupy it. Pakistanis were sponsoring expeditions through the Saltoro ridgeline because between the Saltoro ridgeline and the Karakoram mountains is the Siachen glacier. Ziaul Haq himself telling DG ऐसा है पंजाब में इनको लगाए रख तू and Siachen will take. So Pakistan is not a country which can be trusted at all. Here to sustain 10 men on top of Billafongla probably would have a tail which is of 40 to 50 men. When we were hoisting the national flag over there, just about reaching Billafongla, I find a helicopter coming from the Pakistani direction. He saw that these Indians are already on top of Billafongla. So he took a U-turn and went back.
Namaste, Jai Hind. Welcome to another edition of ANI Podcast with Smita Prakash. Joining me on this edition is my colleague Ajit Dubey, Editor, National Security. 13th April 2023 marks the 39th anniversary of Operation Meghdoot. It was the Indian Army operation to seize control of the Siachen Glacier, which was considered the highest battlefield in the world. In 1984, the Kumaon Regiment, one of the oldest infantry regiments of the Indian Army, and units from the Ladakh Scouts, nicknamed Snow Leopards, were tasked with the responsibility of digging into and controlling the critical peaks and passes of the glacier. Why was this significant? What role did it play in the India-Pakistan conflict? Did we learn lessons from the operation on the LOC, the line of control between India and Pakistan? And has it come into play when our forces deal with the ground situation at the line of actual control with China? To speak on Operation Meghdoot, I have with me Lieutenant General Sanjay Kulkarni, recipient of the Param Vishisht Seva Medal, Ati Vishisht Seva Medal, Shaurya Chakra Sena Medal, Vishisht Seva Medal. Thank you for coming on the podcast, General Kulkarni. It's an absolute honor to have you here. 39 years since Operation Meghdoot. You were a young officer then. So tell us what happened then.
Firstly, thank you very much to have invited me. It couldn't have had I could not have asked for a better platform. Wonderful. Thanks once again. Now going back 1984 that you referred to when we launched Operation Meghdoot. Of course, as a young captain, I was familiar with that area. And that is where we had that advantage. And more than anything else, it is, again, like they say in the army, it's not one man who does it. It's a team that does it. So I owe whatever, now that I am sitting in front of you, I owe it entirely to my men, my seniors, and the battalion that I was commissioned into for Kumar. Having said that, let me tell you that in 1978, to begin with, for the first time, I got to know that something like Siachen is there. That's primarily because Colonel N. Kumar,
Bull Kumar.
Bull Kumar, he was the commandant of the High Altitude Warfare School. And since he was the commandant High Altitude Warfare School, he was taking some officers onto Siachen. And as part of the course, we had to climb a peak called Stoke Gangrene Leh. And we were also there. And that's where we found out that seniors are going in a different direction, and that they were going to a place called Siachen Glacier, and that's where we heard for the first time Siachen Glacier. And not knowing that subsequently in 83 and in 84, I would also be a part of it. Now, how this particular thing came up was because Colonel Bull Kumar, while interacting with one of his own foreign mountaineer, realized that the map that he was being shown had a straight line drawn from a point called NJ 9842 joining the Karakoram Pass. Now that alerted him as to how come this friend of his is carrying a map and has the point joining straight in mountains. You don't have straight lines. And because the Karachi agreement stated point NJ 9842, thence north onto the glaciers. And it wasn't that. It
The
was
Karachi agreement between India and Pakistan.
Pakistan 1949.
UN mandated agreement.
Yeah, absolutely. So that is what it was. So he, when he saw that, it sort of, put him on this thing. He requested his friend if he could give that map to him for rupees 500.
He was a civilian.
Civilian.
That mountaineer was a civilian.
It was Mr. Walker, some German friend of his, a mountaineer, who had done with him previous expeditions and had also done river rafting with Colonel Bull Kumar. And therefore, he again...
Colonel Bull Kumar was still in the Indian Army.
Very much. He was the commandant.
Commandant.
He was the commandant as a colonel of the High Altitude Warfare School, then located at Gulmarg and Sonamarg. And that is where we were interacting. And he said, then when he saw this map, he took the map and he got in touch with the army headquarters. Since Colonel Bull Kumar is from the Kumar regiment, the chief of the army staff then was also from the Kumar regiment, General Raina. And then he got in touch.
Who became chief of army staff later?
General Raina was the chief of army staff.
He was already
He was
there.
already the chief of army staff. So he got in touch with him and he was put through to General Chibba, who was then the director of military operations as Major General. And so he asked him, and Bull was very well known in the army for his exploits as an excellent mountaineer. He climbed Mount Everest, Kanchenjunga, Nanda Devi. So he was a very excellent mountaineer. So he went and obviously General Chibba asked him what brought him here. He said, well, I have a map and wherein the line shown is straight from point NJ 9842 joining the Karakoram Pass and thereby...
This is which year, sir?
This is, I'm talking in 1978. 1978. So he was obviously, he said, is it so? And when he looked into it, he said, yes. He said, now what is it that you want us to do now? He said, before this cartographic aggression by the Pakistanis start, and General Chibba was quite forthright. He said, look, the Chinese have occupied Aksai Chin because we were not at Aksai Chin then. We must not sort of give away Siachen Glacier by not being there. And since it's our area, we must occupy it. How do you plan to do it?
So before we go on to the whole expedition of how you occupied it, you use this term cartographic aggression. If you could just explain to our viewers and listeners what that means.
Cartographic aggression means on the map